happened? Why did you wait for another 5 years to come before this court? What is the meaning of the compassionate appointment there? Where is the compassion left? Who is your senior?
R. Sharma, your lordship.
Where is he?
Lordship, he is out of station.
When is he coming?
He's coming after, he's coming today itself.
Today. On the prayer, heard the Lanark Council for the parties at Samling. On the prayer of the Lanark Council for the petitioner, registered to list this matter again on Thursday, Asani. On Thursday for further hearing. I don't want to dismiss it in your name. That's all.
Lordship, let this matter be taken after some time.
Lordship, may it pleases. Lordship, may kindly have a look at Lordship's order dated 31/2026.
Okay, forget it.
Hello.
We have seen it.
Nothing has been done.
Now they say that because the junior's promotion has been cancelled, so there is no requirement for giving it your promotion retrospectively. What do you have to say?
Lordship, I may take your Lordship to the affidavit filed by them, my lord. Due to overstay, your Lordship.
No, his promotion has been cancelled. There is an order before this court. What do you have to say on that, Ms. Bhuyan? The order is of 5/1/2026.
Yes, may I have a look at that?
The 22/2019 order promoting him from enforcement inspector to DTO was cancelled.
Yes.
Now you were promoted, given that retrospective effect only on the ground that your junior was promoted, you were not.
Lordship, may kindly have a look at the notification whereby his promotion has been cancelled. Page 88, my lord.
Page?
83 or 83.
That's right.
Yes.
That is
Whereas,
that we got it.
yes.
But now the promotion being cancelled, where is the reason for you being given a retrospect?
Lordship, two aspects. Whether Lordship, whether the benefit granted to him has been withheld or not. Nothing has been given. Whether it was Lordship recovered.
Order cancelled, consequences follow, recovery directed. So that argument will not hold the fit. Second one.
Second point is that Lordship, this notification is not clear. On what basis
We
is,
forget this notification, Ms. Bhuyan. We accept this.
my lord?
Then what is your argument?
Lordship, then on that particular point, I'll make my submission.
Make your submissions today.
Today, Lordship,
We are not adjourning this part.
because I have not gone into that aspect of
You
the
have to go
matter.
into that. We'll take it up after some time.
Maybe
It is there in your file. You got to just apply your mind a bit. We'll take it up after some time.
At 2, your Lordship.
Two.
I'll go to detail.
You just give me that what I have in my
Yes,
mind.
yes,
I'll
yes,
pass
yes.
it.
Lord, if I may, my lord, from our end, we have taken recommendations from the finance department and
You forget your recommendations. If Ms. Bhuyan hits on the nail, we are passing the orders.
but the issue is that the finance department being not a party. we now
Forget it.
communicate
Forget
with
it.
the finance
I've
department.
asked Ms. Bhuyan to look into it. Let's her just touch on that point.
My lord.
We will do what is required.
Lordship. Lordship, probably the division bench.
No. In your facts.
Yes, my lord.
Only
Okay.
stick to your facts.
My lord.
Apply your mind. You
My
get
lord.
your answer.
My lord.
It's not good for this court to find that answer. You give me
Lordship,
that
Lordship.
hint, I'll
Yes,
follow. Mr. Counsel, if the Dujendro was not promoted, who would have been promoted? Think over that and give me your answer. Yes, Kima?
May I please, Your Lordship?
This action has been sought from the PO Miller. Respect of the allegation made by the petitioner that the person who has died was provincial. So we also for a report from the VU.
That we had that was on 24/3 itself. For 24/3.
24.
24/3.
Yes.
The order was passed. Why? Why do you think it's not come? Who is the authority not giving you that instruction?
Not like that, my lord.
Then?
What happened, my lord, they was sent on 7th of April, my lord.
10th, 7th of?
7th of April.
Why? Why did he delay?
They have said that the requisition when the notices is all requisition sent to the department.
Now, who is responsible for that? They delay in, then?
Lordship will give us 10 days time. He communicated.
Pradip not provincialized. Science teacher.
Pradeep Nath was not provincial, my lord. My lord, may kindly turn the page 17, my lord. That is the performer, my lord.
Only two provincialized.
Only two provincial, Abhayram Nora and the Toron Chandra Nath. And my lord, the very significant fact is that, my lord, that the
Who is Toran Chandra Das was not alive and
yes, my lord, he expired, my lord, in the year 2016, and provincialized was made in the year 2021, my lord. And my lord, more
Where is the orders of provincialization?
my lord will find that list has been published. That is on page 18, my lord.
No. Where is the order? Was
My
there
lord,
any
order,
order?
my lord, we have
This is
applied.
only the list. Any order passed provincializing Toran Chandra Nath?
Yes, my lord, some order was there. We have made
Where is
some,
that order?
we have, my lord, made some RT applications, but we have, my lord, we have tried our level best, but we are not been able to manage those orders, my lord. But it has been, my lord, published in the website of the official website of the, my lord, the Department of Elementary Education. That is an internet, my lord.
On the prayer of Mr.
extract, my lord.
This court had wide order dated 24/3/2026 directed the Standing Council Elementary Education to complete her submission, had allowed the Learned Standing Council Elementary Education to complete her instructions in the matter and file affidavits. Mr. Kaushik, Learned Counsel for the petitioner submits that the petition respondents had in the month of May informed the Office of the Learned Standing Council Elementary Education that a copy of the writ petition was not received
Month of April.
in the month of April. It is submitted that the said writ petition was inadvertently only forwarded in the month of May. It's on 7/5/2026. According, 7/4/2026, full stop. Was forwarded on 7/4/2026. He submits that the instructions are awaited. Full stop. Even if it is held that the notices, that a writ petition was not furnished to the petitioner, was not furnished to the department when the notice was issued on 19/3/2021, the copy of the writ petition already being furnished to the departmental authorities on 7/4/2026, it is not understood as to why the requisite instructions have not been furnished to the Learned Standing Council by the departmental authorities. Also, the Director of Elementary Education Assam shall invariably furnish to the Learned Standing Council Elementary Education Department the stand of the respondents with regard to the claims made by the petitioner in the present writ petition in writing on or before 8/5/2026. No further adjournment shall be granted to the respondents for the matter. Registry to list this matter again on 8/5/2026. Also, the director shall also furnish the copies of the provincial orders issued towards provincializing the services of the teachers in Karikusi Zonazati ME School.
Obliged.
Actually, last order, my lord.
Yes, what is your instruction?
Actually, partly, actually, I received the instruction. The application of the order dated 18/21, my lord, I need some time regarding that, but regarding the salary of the, my lord, that is being paid, my lord. Salary, the third prayer which he has made. My lord. The other aspect, my lord, I have been communicated that, my lord, and maybe
Mr. A. Fukun, Learned Counsel for the Learned Standing Council, Elementary Education Department submits that the salaries of the petitioner are being regularly released. Salaries of the petitioner are being regularly released. He submits that he be granted further 2 weeks' time to receive instruction with regard to the claim of the petitioner for a change in the base school as identified for provincialization of the services of the teachers working in, what was that school's name?
Lordship, Sodor Bazar, Adorsho ME Madrasa,
Sodor Bazar Adorsho ME Madrasa,
under Rupsi Block, Borpeta.
comma, under Rupsi Block,
Borpeta district.
comma, Borpeta. Prayer accepted, registry to list this matter again on 13. 2 weeks later, no? On 15/5/2026.
Obliged. As an interim order that may be continued.
Interim order passed earlier to continue till the continue until further orders.
Obliged.
Not received. Okay, when did you communicate this to the respondents? Huh? No, tell me, what did you do with this order? This cannot be an order in paper only. It has to be implemented. What did you do with this order?
It was
We don't differentiate between you and Mr.
Yes,
Trippier.
yes. My file, Lordship.
That means this was not communicated. Explain why this was not communicated.
I will communicate.
You are delaying dispensation of justice. We can draw up a contempt proceeding.
I will come.
We don't have that fate now, Mr. Because you will not be found on the next day. Guarantee.
Lordship, I definitely, I will.
Sorry, today we are taking it up. Why the instructions? Only a small instruction was required, a clarification. And that is the thing which will have the effect of disposing of this petition, either allowing it or
I
rejecting it.
do it. I do it.
So you get your instructions, we'll take it up after some time. Not adjourning it. 27(3), or give me the person who is guilty of not communicating. Today, sorry. No, we don't have time. You may have much time. We don't have time. Tomorrow we can take up some other matter. Why should we be going behind this? And Mr. Soikia, 5th pay commission adopted. 6th, 7th not adopted. What right do you have? We can't force them to adopt that, can we?
But the corporation, my lord, they have,
Corporation is an independent authority. This payroll, this revision, ROP rules don't automatically apply. It has to be adopted. Then a memorandum of
my lord,
understanding.
corporation has adopted, my lord. That
Where is that
only-
material?
Only that,
No,
only
where is that material? It's not here.
the petition perhaps, my lord, is there, my lord.
You have not brought on record any material to demonstrate that. 6th and 7th. Show me that the corporation had accepted it. And it's a dying corporation.
My lord.
You're still working.
Oh, you have retired, my lord. You have retired me.
You have been given VRS.
No,
What happened?
my lord, by attaining the age of superannuation, they have.
You replied. And what about the other employees who are there, who had not attained superannuation?
They are
It's
working, my lord.
working.
They are working.
Just show me that this
The
was
corporation is,
adopted.
my lord, they have, the corporation has revived, my lord, that is working properly, my lord, now. Now
So
it's
show me that the corporation at any point of time, when you were in service, had adopted the ROP rules of 2010 and 2017.
Page 33, my lord,
30?
33, my lord. 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 33, my lord
Hmm.
Minutes, my lord.
This was adopted on 16.
16, my lord.
And on that day you were working.
Yes.
When did you retire?
These petitioners,
15/2, 31/12, barring one, 16/2/17, 21/10/17. How many petitioners are there? 5.
5 petitioners.
Barring 2, the rest have already retired.
Yes.
So these 2 were, whether they were given this benefit? No. Although this court had directed wide order dated 27/3, although this court wide order dated 27/3/2026 had passed the following order. Para 2, 3, 4. I order dated 27/3. Mr. J.K. Goswami, learned counsel for the respondent, submits that although they said order was duly communicated to the respondents, no instructions are forthcoming from the end of the respondents. Also, he submits that he would complete his instructions in the matter and place the same before this court on 29/4/2026. Also, prayer accepted. In the event the instructions are not furnished to Mr. J.K. Goswami, who is to come? The competent authority to furnish the instructions would be required to be present before this court. Also, to assist this court towards disposal of the present writ petition, registry to list this matter again on 29/4/2026, reflecting the name of Mr. J.K. Goswami, learned additional senior government advocate for the respondent.
Obvious.
What happened to the appeal? Closed. The orders upheld or modified.
Upheld.
What is left now?
I've given.
14 of
I-
the late appeal.
What is there?
It went on a hell that since it was initiated. Can there was no sufficient occasion for the employee FCI to find the guilt of negligence
Hmm.
of the respondent. Often for the appellant FCI and the so did we did January.
Hmm.
Third, my lord, I need my lord, whether
But this order was passed on.
May,
Para.
93 in Israel. And like that, it was a listen. For the losses, not be established. Yeah, does mean anything in the percent of appeal as far as recovery is concerned. It's only profitable for the tackle.
This aspect I have already taken care of in para 34 of my judgment. That in the event the petitioners were considered, only because of this penalty, they were not promoted. Open the seal cover and proceed. That has not been interfered by the division bench. Now,
That has not been interfered.
Mr. Singh, today those proceedings have gone. So if you initiate a fresh proceeding, that will be a fresh proceeding from today. How can you block his promotion prior to that? Can't. You can't. Because now on the day when he was considered for that promotion, he is blameworthy. He is not blameworthy. Done with. K.V. Janaki Raman, the seal cover has to be opened and retrospective promotion. Once he gets his retrospective promotion, other things fall into place. Seniority, seniority, everything will come back. Now, if you institute a proceeding, it will be again prospective. It cannot be a retrospective one.
It will be.
You argue on that. That's the only area we have to consider. Nothing else. Everything is taken care of.
Can it be taken next Monday? Or not on this point, whether it will be prospectively or otherwise. The instruction whether anything has been initiated.
Heard Mr. G.K. Gupta, learned counsel for the petitioner. Mr. Gupta has submitted that the penalty of recovery only, no? Recovery as imposed upon the petitioners in the above noted petitions were interfered by this court. And thereafter, the matter was considered by the division bench of this court, and the set and the interference made with the recovery was upheld. However, liberty was granted to the FCI authorities to proceed de novo in the matter if so advised. So, Mr. Gupta submits that the proceedings, if initiated against the petitioners, would be only a proceeding which would be prospective in nature, and the same cannot have any effect on the promotion of the petitioner, for which consideration was already made, and the findings of the selection committee kept in the seal cover. This is the essence. Mr.
One more thing is, in page number 101, this has been submitted by the minor subtotal promotion committee. In page number 103, under vigilance status, it says promotion of government servants against whom disciplinary court proceedings are pending or whose conduct is under investigation is decided in terms of DOPT circular OM such and such. Promotion of persons undergoing a penalty is decided in terms of DOP circular this way. However, promotion of this is I want to impress upon. However, promotion of persons on whom
Mr. Gupta has further submitted that the selection committee, while considering the case of the petitioners in the above noted petition for their further promotion, had also noticed that promotion in respect of persons on whom penalty of apostrophe beta, recovery of losses apostrophe close is imposed can be promoted from the due date, and the recovery of his pay can continue in the higher post, in terms of FCI headquarter circular, circular number 219/20/2001, issued in connect with reference to a vigilance communication dated 27/12/2001. Also, in view of the above submissions of Mr. G.K. Gupta, learned counsel for the petitioners, Mr. B.K. Singh, learned standing counsel, FCI, submits that he be granted 10 days time to 2 weeks time to complete his instructions in the matter and apprise this court as to the further steps taken by the FCI authorities after the passing of the orders by the division bench of this court. Also, prayer accepted, registry to list this matter again on 13/5/2026.
Yes, in page number 104, Ankit Kumar has been shown as fit, free.
We'll come to that, mister. We'll come to that.
Apply.
13 to clear. Mr. Chakravarti raised one item 13.
Just praying for him. Everything comes Thursday because he has been state lordship. And we have, his caste certificate was cancelled as per direction of the division bench lordship.
It all to me.
Just praying for some adjournment lordship on Thursday.
No, no, we'll get it. Just one item, material 30. Just, there is one item ahead of that. None appears for the petition on call. Registry 13. Registry to list this matter again after 3 weeks on a date to be fixed by. Yes. The committee's report, caste scrutiny committee's report is under challenge in the second case.
And an entire action type has been taken on the basis of the DB judgment.
Yes. What is the ground for adjournment? That ground will not hold the field because you know item number 14. And Mr.
There is some passing difficulty.
That I can understand. A prayer is made on behalf of Mr. P.D. Nair, Learned Council, appearing for the petitioners in the above noted writ petitions for an adjournment in the matter on account of person inconvenience. Mr. B. Chakraborty, Learned CGC, appearing for the respondents, however, submits that there is an urgency in the matter and a short adjournment be granted. Accordingly, as agreed to by next paragraph, accordingly, as agreed to by the Learned Council for the parties, registry to list this matter again.
He's standing for
7
Any-
on 7/5/2026.
Obliged, highly obliged.
Just write down M.R. Odhikari and S.G. Burwa. Miss M.S. S.G. Burwa and Mr. M.R. Odhikari are present. Learned councils are present for their respective respondents.
There is some
Ekalage
interim order
file,
lordship, it may be
15,
continuous.
14,
14 and 15.
I eta ase. Taisho item number 15. Ekalage tinta mari order to my.
The interim order is component.
Interim order passed earlier to continue till the next date of listing.
7th, obliged.
Yes, what happened? Have you got the money?
No, lordship.
What happened then? Yes, who is appearing for the respondents? Secondary. Mr. Sinha got us to review an order. It is listed today. There was none appearing.
I will ask.
You did not ask. We have already adjourned it. 6 weeks.
In this case, malat, this honorable court malat passed the similar judgment malat. Prior to regulation malat.
Now tell me. Here,
The length of service more there.
Died during the course of
show me
service, malat.
where, how you have completed 20 years. Even if we deem it.
Malat,
Without 20 years, you are not getting it.
malat, died during the course of service malat. Rule 140 malat.
You were
Minimum
not,
1 year
not
service is-
regularized. Not regularized. You died in 2044. Regularized only in 2005. And what about the delay?
Delay malat,
What is the explanation?
regarding malat, it malat respondent number 4 malat file affidavit malat.
Hmm.
The regularization process of regulation under process before the hierarchy
We
stated.
got it. Your husband died in 2004.
4.
Regularized in 2005. writ petition in 2023. How did it suddenly the writ petition come into being?
But
For around 17 years, there was no issue. 16, 15 years, there was no issue. No pension required, nothing on record that you had. Then why the suddenly a writ petition has come in? How? What is the background?
that lady, my lord, illiterate lady, my lord, there is no. He approached the.
How did she suddenly get a spark to file a writ petition? What was that spark?
Pension is the, my lord, family pension, my lord.
I got it. But what is the spark?
And
We
my
want
lord,
to know this
regarding
spark.
family pension, my lord, the respondent.
Mr. Padgiri, those are things which are settled by law.
My lord.
But I want to know why the delay.
Delay, my lord,
Where is your explanation with regard to that delay? You can't walk into a court as per your own will. And if she did not know about it, how did she come to know that, okay, I can file a writ petition?
subsequently filed, my lord, come to know, my lord,
Where have you
representation, my lord. In
Where
the
have you
draft
written?
Paragraph 23, my lord. Paragraph, my lord.
Paragraph?
My lord, kindly say page number, my lord. 37, my lord.
No, in the writ petition, where is the reason?
My lord.
37, my lord, is section 3 only.
11 paragraphs, I could go through it
My lord.
immediately. There is nothing.
But my lord, in the Supreme Court, my lord, says that, my lord, regarding pensionary when a delay is not applicable, my lord.
But I want to know why. Is the lady alive today?
My lord, alive, my lord. And my lord, kindly last order, my lord, is before the mediation, my lord. But
Mediation failed.
mediation failed, my lord. 6 and 7 stated that, my lord, hence no regulation, my lord, then family pension does not arise, my lord.
Heard Mr. K.R. Padgiri, learning counsel for the petitioner. No further affidavits are required.
No, my lord.
Uh,
Only respondent number 4 file, my lord.
Also- Also heard Mr. R. Learned standing counsel.
I'll inform the finance department if they want to file.
I don't know if they should have been here. Who are you? It is submitted, the pleadings are complete and the matter can be taken up for final consideration. So accordingly, registry to list this matter again on 19/5/2026. An endeavor would be made to dispose of the matter on the next date of listing.
My lord. Obliged.
Kiman dito. Nasil, none appears Asil, na? Pwede ko na.
Pwede mo.
Malay. Dahil siya.
My third. In terms of the order
He
detail.
has given the justifications. Have you taken a call? 205, 206 relaxed.
That was per rules 206, 205 shall apply to the ordinary, not to the special. If under special circumstances, pension is granted long after of officer has retired, according to this process and obtaining special order from governor, that is the instruction.
Who has given that instruction?
That instruction.
Which department?
Legal.
Women Political. Has the file gone to the pension department? Show me that instructions.
Copy as a.
Are you getting a provisional family pension?
Because earlier, but by virtue of this honorable court's order, he is allowed.
Mr. J.K. Goswami, learned counsel for the petitioner, for the learned additional senior government advocate, J.K. Goswami, additional senior government advocate, appearing for the state respondent, submits that the matters that the pension proposal of the petitioner is under process for condoning the delay occasioning in submission of the same. He submits that the said process would be completed within a further period of 3 weeks from today. So the respondent authorities are directed to complete the requisite processing involved in the matter within a period of 3 weeks from today, and thereafter to forward the pension proposal of the petitioner to you, to the accountant, office of the accountant general, bracket A&E Assam, for disbursal. Also, registry to list this matter again on 25/5/2026. Also, on the next date of listing, Mr. Goswami shall place before this court the documents envisaging forwarding of the pension proposal to the office of the accountant general, bracketed A&E, complete in all respects.
Much obliged, Lordship.
Mr. Goswami, there is delay, there is Tarsem Singh. You give it to him from the day one, on the day you sanction. Who is stopping you? But why are you sitting over the matter with regard to a pension proposal?
That regarding the delay, Lordship, that was not explained by the prisoner, Lordship.
Fine, he has now given, we have asked him, he has given you that.
Yes, that is.
Take it up, reject it.
That is
Mr. Goswami, reject it, say that no, you will only get it from today. Fine. But give it to him. They are suffering.
The response from their side is required, Lordship.
I got it. They gave it in March only. Today we are in May, April, nearly going to May.
Explanation.
Yes, yes. He has submitted a letter to you and you have received it.
That
And
apart-
your letter itself says on receipt of explanation from.
And that part also in 2016 also, Lordship.
Mr. Majumdar. Ask your authorities to do the needful immediately.
Much obliged, Lordship.
Writ appeal is pending. This question is arrived. Yeah. That was of the earlier, they placed a judgment, my lord. Yes, let me submit, my lord. Earlier, they placed a judgment that is of Nalbari district, and factually it is completely different. And your lordship was to pass order, hearing is already completed.
Madam,
Yes,
Madam, the matter, Ganesh Narzari and others, is a matter pertaining to Baska district. WPC 6020/2017.
Writ appeal is preferred by Commissioner.
It's pending. Any stay order?
Ganesh of which district?
No,
Which
Baska.
district? Which district?
Baksa. Musalpur, Baksa. And therein that same very issue was taken into consideration by a coordinate bench of this court, a detailed order. Have you gone through it?
Passed by?
My Lord Justice Chaudhary?
That is in my hand, my lord. That is of Nalbari, my lord.
No. This is Baska.
A.D. Chaudhary.
A.D. Chaudhary.
Yes, my lord.
Writ petition number?
Filed the additional affidavit,
Writ petition
giving the
number?
comparison, yes.
Writ petition number?
WBC number to kya nahi aata? Number 19. कितना था क्या नाम? Printed number is not there, my lord. Advocate appeared R. Sinha, R. Devi. Okay,
Can you just show me that once?
this is the. Six zero two zero of 2017. Ganesh Rajari
So,
and 116 others.
okay. Third day, learner counsel for the parties
That's
at length.
I have filed an additional affidavit.
Yes, yes.
Giving the
Hearing
comparison.
concluded. Hearing concluded. Registered to list this matter for delivery of orders on 19/5/2020. We'll pass the orders on 19.
Right.
We'll take into note
Because-
everything. Madam submission also your that decision. We'll take both. into-
Additional affidavit filed, my lord,
Yes,
giving
yes,
the
absolutely,
comparison that that is different issue. All right.
My lord, rejected due to medical unfitness, my lord, at the recruitment rally. The advertisement,
Mr. Pathak,
my lord,
you have relied upon a guideline, revised scheme.
my lord,
Therein I don't find medical review. Review medical board.
my lord,
So it is medical board, then an appeal.
appeal.
So that you already have that. You were already placed before the, what do you call that? You were sent
Review
to
medical board.
review medical
My
board.
lord, the
What is
advertisement
required?
says that there will be firstly the DME, then a RME.
But it does
After
not say.
DME, I was placed in RME.
No, this latest one,
My lord,
wherein page 76,
my lord, yes, yes.
therein it's only one board. And then it says at page 79, 8,
79, my lord, 5 and 6 clause.
Ah.
There is a
it is only contemplates one board and an appeal.
appeal panel.
You have already got that scope.
I have got a review medical, my lord. I got
Because
a-
that is the appeal. We'll have to take it that. And you were found to be, this is
My lord, of course.
This is
Medical fitness, my lord, is something that court cannot.
we
go in.
cannot go in.
We cannot go in,
We'll give it a closure now.
my lord, because in
We'll hold that. You have already got an appeal and no further
Yeah,
appeal is.
our contention was that technically, my lord, as per the advertisement, automatically those are, my lord, placed, who are rejected in the DME are placed for the RME. But then I did
But-
not get a chance to
But you have
represent
also
myself
sent
as
to-
an appeal.
You have also been. sent to-
Technically, I have not filed an appeal, but then they have considered it as an appeal, my lord.
You have also been placed before the Negrims authorities.
My lord.
And they have also given an opinion which is in tune with the opinion of the
Authorities.
two boards. So we'll close it. Ready. I'll pass the order in the second half. He's a new man. He will not be able to take it. Second half, I'll take it. The second half will deliver.
21, my lord, again pertains to recruitment. My lord, here the allegation is that the private respondent had applied from the UP quota. And whereas,
Is that the only point you want to take up?
yes, my lord.
Okay.
And
What is the material to show that
lord-
he is not from?
we had, my lord, shown a Aadhaar card which shows
Yes, Mr.
a
Chaudhary.
different address.
Mr. Chaudhary, what has happened to the verification process? You get that? That'll settle the
They
issue.
have already written.
Submit some. Again, his appointment will be subject to verification.
That is it. In
Hello.
para page 38, para 9, you have taken that. Please.
I'll get that updated.
In fact, the SC certificate also, my lord, of the
That
respondent,
he has
SC
dealt-
certificate also shows a Haryana.
Mr. Pathak, that he has dealt with that in his reply,
My lord.
and he says that that certificate is a forged one.
No, no.
Certificate, he has said.
No, he has said about, my lord. Aadhaar.
I'll show you that paragraph.
yes,
There
on
is
the
a
Aadhaar,
paragraph somewhere. Copy of the Aadhaar card annexed as so-and-so is a fake and fabricated document. This document is not on record.
The scheduled caste certificate I have just recently obtained.
Oh.
After they filed an affidavit, I obtained, my lord.
Heard Mr. B. Pathak, learned counsel for the petitioner. Also heard Mr. R. K. D. Chaudhary, learned senior counsel, and the deputy SGI, assisted by Ms. S. Borua, learned CGC, appearing for the respondents. Mr. Chaudhary submits that the verification of the antecedents of the petitioner of the respondent number 7 was underway, and he would require and the
Right,
updated instruction, an updated status with regard to the same would be placed before this court on the next date of listing. When?
Lordship,
On the accordingly, a registry to list this matter again on 15/5/2026. Also, on the next date of listing, the outcome of the verification process of the permanent residence as well as antecedents of the respondent number 5 be placed on record by the learned by Ms. S. Borua, learned CGC, assisting Mr. RKD Chaudhary, learned senior counsel, and DYSGI. Anyway, congratulations.
thank you. This is the first order where lordship has reflected.
The honor was for me.
Lordship,
May it please the lordship. Here, your lordship, I'm challenging my non-approval in the post of library assistant in the THB college.
Now, Mr. Dotov, we'll come to the other part.
Yes.
Other part, there is some confusion with regard to the roster register. Not very satisfied. But what about your 10% thing?
10%, your lordship will find that there are two assessments which were made. In the year 2023, one assessment was made by the medical board. There it was shown that I was disabled to the tune of 23%. Then recently, which they have reassessed,
So,
that
you were 40% in your original
in the
certificate
original certificate issued by the government.
issued by the government, it was
Yes.
40%.
Yes,
It got down to 23%.
23, then 10.
Now, that means your thing is, it was just a temporary disability. It is improving. So if it is improving, you're not entitled to PWD. Right?
Yes.
So you will not be entitled as a PWD, and the post being advertised as a PW
PWD.
thing, you will not stand to gain. So we'll have to close it. Liberty is to you to also apply.
Your lordship will find that another advertisement was issued thereafter.
Hmm.
So that is for you.
What happened to the second advertisement? Okay, so no applications received. He did not apply.
Because your lordship, in the meantime, my age limit has crossed.
Can't help it.
So at least I may be considered.
How will be consider you? You have not even put that to challenge before this court.
No, we have challenged the second advertisement also.
Challenge the second advertisement. Second advertisement is RP.7.
RP.7.
No, unreserved.
Unreserved and roster 0.7.
Roster 0.7.
Yes.
Is the second advertisement under challenge in this process?
Yes, yes. Your lordship may come to the prayer portion. At page 18 of the writ petition.
Yes, Mr. Upamanyu. Explain this page 89 roster.
80.
In our country now, the running roster system is not there.
If it filed by the college authority.
But it's your document. No, it's your document. Mr. Hazarika, this is your document. 89, page 89. Okay, 87.
Page
There
87.
is a correction in that. 87, okay. Okay, explain this to me. How have you prepared this? This is the roster register you are having now. How have you prepared this? How many cadre posts are there?
Total is 4.
Right? How can you have a roster point beyond 4? You are an unreserved candidate, community.
I am unreserved.
4. How have you gone till 7? Say, the concept is once you have the cadre posts are filled up, the operation of the roster stops and it will then be a replacement. Now it is being only a cadre of 4. You will have to follow that L shape. Right? Now you come to the roster. On the date you have advertised the post, there was no vacancy. Which was the vacancy? When was the retirement? And when did you advertise? No, first one.
First one is 22. 19/5/22.
25, 22.
19.
19.5.
Yes.
On that day, where was the vacancy? Yes, Mr. Hazarika, what is your answer to this? Why? What is this? 5 minutes. Okay. I'll tell you more. Bhavananda Bora only retired on 31/1/2023. Next one is Mukut Bhuya. Right? He was promoted on 2010. Right? Now, in place of Mukut Bhuya, serial number 4, Pankaj Sharma was appointed on 11/10/2010. Right? Then Bhaven Busumatari. He was promoted in the year 2011. In his place, Minmoy Datta was appointed. So the 4 posts literally filled up. Right? There was no vacancy. Now, today, if you have to advertise it, whether it by following that, it will be an unreserved post. It may not be an unreserved post. Have your instructions? We'll take it up in the second half.
Obliged.
Mr. Datta,
Yes.
if I hold that it will be an unreserved post, your case gone. Even if I hold that it will be a reserve post, still your case goes. Either way, you are out. But anyway, we'll do that exercise. To get my point.
My lord, this is not non-consideration of the third MSAP benefit. My lord, they said that 21/22 ACR was met.
Did you file a?
I filed a representation, my lord.
They have not considered.
In reply, they said that we have lost it. Though we received it, we have lost it. Para 9, page 56, my lord.
Why? Consider that.
Para 9, page 56.
And madam, don't you furnish to them all the ACRs? Adverse, not adverse, that thing concept is gone. Every ACR is to be now furnished. Have you furnished? Have you furnished to him? You have not said anything. If you have not furnished to him, you will have to ignore that.
Yes.
Take the other two and then proceed. And the other three also we take. We don't know what it is there prior to that
My lord.
or subsequent. Other two are very good FCACs.
It may, witness.
On the prayer of Ms. R. Devi, Learned Counsel for the petitioner, registered to list this matter again on 8,
That will be on 11 or 12.
11/5/2026.
Likewise.
Plus, Ms. Devi shall apprise this court as to the manner in which, as to whether there was any, but they have not taken from you a copy thereafter,
My lord. I am not.
as to how uncommunicated ACR would be permissible to be considered by the selection committee. Also, further, she would also apprise as to how they said SCR, the gradings made in the said SCR would continue to be considered as adverse when the application filed by the petitioner was not considered and the same was same has been projected in the affidavit to have been lost. Ms. Devi shall apprise this court as to whether the respondents had taken any further steps to get a copy of the same from the petitioner. Full stop.
Obliged, my lord.
Kindly see the last order, my lord.
Yes.
His services were provincial pension. Services were provincial and the order is there. Second part, turning pension, it was rejected by the finance department. It was rejected by the
Where is that rejection?
last page.
Okay.
My lord, kindly see, my lord, page number, my lord.
This is the
50
first writ petition you have filed?
My lord. 50, page number 53, my lord. The continuous qualifying service counted from the date of regulation, my lord.
We got it. It will be from that date.
My lord.
But you will get your areas only from 2021, not before that. Tarsim Singh.
My lord.
You agree to that?
My lord.
Agree to that?
My lord.
We'll follow our orders. Wherein we said that from the date of their first entry, that date,
Similar order, my
the pension has to be that period till his date of death has to be construed as qualifying service. We'll only follow that. But because of the delay, we'll say that it will be following Tarsim Singh 3 years prior to. You'll calculate it from that date, but areas will be released only from 21. Disposed of.
Obliged.
You will have it by Wednesday or Thursday. Yes, done. Released. You got your money.
No, my lord.
Why?
In this letter also they have commit mistake, lordship. Lordship, the date of commencement of the lordship, the pension lordship. Earlier order lordship 2/5/2022. Here it is mentioned with effect from 3/8/2020, 3/8/2017. Whereas my father died lordship on 11/3/2016.
Oh. Then your mother was receiving pension.
No, no.
Father died on?
11/3/2016. No problem.
Now you are getting it from, have they given it to you from 3/8/2017?
Now, Lordship.
Now they have given it.
Now, by this order, Lordship, they are allowing 3/8/2017. Lordship. Earlier,
Yes.
they allowed while
Where is your father's death certificate?
do I have another?
Who is for the department here? Animal husbandry and veterinary?
Father's death certificate is page 14, Lordship.
Where is Madam Kotoki? Hope she is fine. Tight control also. Tight control also, or tight like before, huh? Ask her to diet, take control of diet first. Now, Mr. Burwa, your proposal was from 3/8/2017. Okay, that is a minor thing, we'll get it done. Let Ms. Kotoki come back. A prayer is made on behalf of Mr. Enagali. Mr. C. Burwa, Learned Standing Council, AG bracketed ANE bracket over Assam, has submitted that the family pension of the petitioner has been authorized to her with retrospective effect, that is with effect from 3/8/2017. He further submits that such retrospective effect was granted basing on the documents furnished by the Department of Animal Husbandry and Roman and Veterinary Department. Also, the Learned Council for the petitioner submits that her father having died on 11/3/2016, the petitioner was entitled to receive the family pension with effect from 11/12/2016 and not from 3/8/2017. Also, the Animal Husbandry and Veterinary Department authorities shall apprise this court through their Learned Standing Council, Ms. M. Kotoki, about the said discrepancy with regard to the date from which the family pension is to be authorized to the petitioner hearing. So, we'll have it after 3 weeks. Registry to list this matter again on 26/5/2026. Ask her to take that instructions, or she did not come, she can send it through you. Correct? Vijay? তোমার নাম তো কি হ্যাঁ কালো বলা ছিল নাই নাকি নাই নাকি
Comment have been received. It is sent to the team. It's sent for vetting also.
It has been, they have been taking time for several occasions.
We want the instructions today, or we'll adjourn the matter with the cost of 50,000 to the petitioners. You have been taking time for the last 1, 2, 3, 4, 5 days. Mr. G. Bodloy, can't help it. Get him here.
Is relating to Sanskrit teacher's case.
Help it. This is not similar. This is not similar. You had approached this court earlier.
Yeah.
This court had directed for 2017 consideration. That order is still holding the thing. Neither you have reviewed it, nor you have taken it upon appeal. How can we go beyond that now? And there is no direction here for consideration like those two cases that I disposed of subsequently.
But here, in this case, Lordship, the director also says that my name was recommended by the
Can't help
DSC.
Can't help it.
Else,
There is
Lordship,
a order
my name-
already.
Lordship,
We'll have to get that order reviewed. Otherwise, we can't do nothing here.
as Lordship, petitioner name was recommended by the DSC, then
got
Lordship,
it, Mr.
2011 Act,
Mr. Sinha, there is an order of this court
Lordship,
that you came up, we said no, 2017. Right, wrong, that order is existing. It might be an illegal order, but that order is holding the field. How can I go beyond that? You take time, you file a review, file an appeal, get the thing sorted out, come back, we will see. On the prayer of Mr. S.K. Singha, Learned Counsel for the petitioner, registry to list this matter again after 2 weeks on a date to be fixed by it. You do the needful. Other two cases that I dealt with, where there were orders, right? So there was no issue. I passed the orders, directing for consideration. But here there is no such order. The order is the other way around.
next case is also same Lordship.
দুটো একে, হ্যাঁ? বেলেগ বেলেগ কে মাইবা? Obvious.
May pleasure, Lordship.
Mr. Chutia, congratulations.
The first case.
Huh?
The first case I have appeared before.
Mr. Akedi Chaudhary also said the same thing. Yes.
Whether, my lord, he would be prepared to lose the first case, my lord, that is.
Let us see. The stars may be on that side also. Mr. Chaudhary,
My lord, the issue before Roche.
promotion.
Whether, my lord, the ex-serviceman employed in Assam Police Border Organization, they will be entitled to.
Now you show me your appointment was against a permanent post.
My lord, that permanent,
It's a temporary establishment.
yes, my lord.
You will get all benefits in terms of the Supreme Court order. But Supreme Court said no regularization.
Yes,
One.
my lord.
If you are not regularized in the feeder cadre, how can you be promoted to the promotion?
Now, my lord, subsequent to Supreme Court's order, my lord, our services have been regularized.
Where is that order?
Your lordship will find, my lord, that page 59A. This is an order by the Home Department, government.
59A.
My lord.
Hmm.
From the, my lord, Home Department Deputy Secretary to the Additional Director General of Police Border. In inviting
60A.
reference
60A.
59A, my lord.
59. No, where is that regularization?
My lord.
Regularization is not here. You are given the pay, everything, no problem.
Regular employee with effect from the date of joining.
Fine. Treated as regular employees, no issue. But there is no regularization because Supreme Court said no regularization. Two, you are not in a feeder cadre for promotion. That cases where the regularized employees, that muster roll workers, they were regularized and then they sought promotion. They are getting, even they are getting pension under the pension rules. But they are not entitled to promotion. That's what this court in Motiur Rahman. held.
Madhur Rahman.
So same principle will apply here.
Now, my lord, my lord, the government is a state, my lord. They have said that, my lord, we are regular employees, my lord.
No, regular employees means that's you have to understood in the context of the Supreme Court order. Supreme Court said, give them all the benefits that is flowing to a regular employee.
Supreme
But
Court,
no regularization. 2009 6
my lord, if your lordship kindly comes to the Supreme Court judgment, my lord, at page 46. My lord, several findings have been given.
Show me that finding which is favorable for you to in this writ petition.
Page 53, it says, my lord, that will not be entitled to regularization. That your lordship has already noticed, my lord. Paragraph 6 at page 51. At the outset, the learned counsel for the appellants stated that the prayer for relief based on the scheme dated 14/6/1984 related to Assam Special Peacekeeping Force was not pressed. Therefore, only two issues arise for our consideration. Number one, whether the person engaged under the PIF additional scheme 1987 are entitled to be regularized in service, and whether the procedure introduced by the circular dated 17/3/1995 is valid. That has been, my lord, quoted at page 48, my lord, that particular scheme. Now, if your lordship comes to page 53, my lord, the last sentence, it says, first paragraph, last sentence, in view of the settled position, the appellants will not be entitled to regularization.
And
That has been-
that for us,
Yes, my lord.
what is relevant is para 7. Page 52.
The fact,
Additional scheme.
may I read it, my lord?
Yes.
The fact that the appellants were employed under the PIF additional scheme is not disputed. The duration of PIF additional scheme under which they are employed was initially 2 years to be reviewed for continuation along with the original PIF scheme. The SAGE scheme is being extended from time to time and is being continued. If the temporary or ad hoc engagement or appointment is in connection with a particular project or a specific scheme, the ad hoc or temporary service of the personnel employed under the project of the scheme would come to an end on completion, closure, cessation of the project or the scheme. The fact that the scheme had been in operation for some decades, or that the employees concerned had continued on ad hoc basis for 1 or 2 decades, would not entitle the employee to seek permanency or regularization. Even if any posts are sanctioned with reference to the scheme, such posts are sanctioned with reference to the scheme. Such sanction is of ad hoc or temporary posts, coterminous with the scheme and not of permanent posts. On completion of the project or discontinuance of the scheme, those who were engaged with with reference to or in connection with such project or scheme cannot claim any right to continue in service nor seek regularization in some other project or service. So, my lord, case laws have been, my lord, noted.
Then this. So here, the Supreme Court is very clear that you cannot be given a permanency. Now, if you can't be given a permanency in a feeder cadre, how can you be considered for promotion?
My lord, may I draw your lordship's attention to, my lord, my lord, the Supreme Court also held, my lord, that will be entitled to increments.
That
That
everything,
has been held,
all benefits you will get.
my lord. Now, if your lordship kindly comes to an order of this honorable court, my lord,
Yes.
that
Okay.
is page 69, my lord.
69.
My lord, these were filed by similarly situated persons. The petitioners
Oh,
were,
this is by me.
my lord, but then the petitioners were not there, my lord.
Okay.
Petitioners were not, but similarly situated persons approached, my lord, this honorable
I
court.
think it's on the same issue, Mr. Sir. I think I should not be.
I was, my lord,
That I missed out.
that is one of the reasons why I pointed out this order. my
I
lord.
missed out. Heard Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr.
Argohai.
R. Gohai, Learned Counsel appearing for the petitioners. Also heard Mr. P.C. Shutia, Learned Senior Counsel, assisted by N. Islam, Learned Counsel appearing for the respondents. Registry to list this matter before any other bench without me. I just wrote that only to get that name in.
My lord.
The first one to do that. I think I should not get. I know it's not related, but still, why?
My lord, the
Otherwise also I'm against you. Because that decision is there, that will apply.
Supreme Court should.
And there is one order at page 60. 60, type copy. Wherein after following the Supreme Court, the government has taken a decision that you will be against ad hoc posts, but you will get all the benefits.
That's right.
Okay.
Obligation.
Mr. Bhattakur, congratulations.
Thank you, Your Lordship. Highly obliged, Your Lordship.
This.
That was already given to you. 18.3. Mr. Mr. Das, what is here? Nothing. He is entitled from, if he is entitled from a particular date after completion of a period of service. Now he says 8 years. I don't know from where Mr. Bhattakur is saying 8 years. I'll ask him. Normally it is 4 years with PhD, 6 years with MPhil, and otherwise 5 years with MPhil and 6 years with otherwise. But only requirement is that within this period, 21 days orientation program or refresher course, 2 has to be completed. Whether he has completed. Now you find him eligible from 24. Why not from 21? Why not from 20? Whenever. That's the only instruction I require. Ask Mr. Upamanyu to come and give us that. We will finish it off.
Inform me that the instruction, madam.
Okay, call Mr. Upamanyu. Time being, Mr. Because here there is nothing else to be looked into. That's all. Whether he says that he has brought on record certain refresher courses. It's for you to look up into. If he has completed within that period, fine. If not, it will go beyond that to the extent when he completed. That's all. But why 24? Why not before that? Because I find that the refresher courses were of 2001, 2, 4, just that much only. When Mr. Upamanyu is available, have Mr. Bhattakur also, then we will take up the matter.
Raised two cases, Your Lordship,
Same. Slightly.
slightly different.
Slightly.
Deeply obliged, Your Lord.
May it please your lordships, this case relates to opening of the portal. This honorable court has already been passed an order, my lord. That order actually I want, and lordship kindly pass an order to open the portal, my lord, because they have already.
Where is your permission? And whether you are a, Madam Devi, whether
Yes,
you are a high school wherein a higher secondary school was opened, high school is provincialized, is the same case?
Same case, my lord. That
Same case.
Yes, my lord.
When have we fixed those matters?
It is, no?
On
Thursday.
Okay, then yes.
Huh?
Oh,
No. I fix some matters.
yes.
Did come about in
Who?
number 4 now.
Those matters are listed. Huh?
Fixed on Thursday.
Thursday. Register to list this matter.
Hey.
Number
Along with WPC number. Can you give the WPC number? Give it to him. So and so. On Thursday. On. No, I fix along with so and so. Because that same thing will hold here also.
Yes, yes. And similarly situated person, my lord, their school has already been opened.
No, when they say that you are a government school, what more is required?
No,
That
it
is
is not government school.
No,
My
no,
school
no.
is
Yours is upgraded.
not upgraded.
Or not
Upgraded to
upgraded.
11 to 11 and 12.
No. There is no high school attached to this.
High school is there. Then
High
it is
school is
opening to
provincialized.
11 and 12.
High school is,
We
high school is-
applied in the year 2005,
high school is provincialized.
long back.
That's it.
Yes,
High school opened this school to
yes,
secondary.
yes, madam.
Same thing.
Correct.
34, 35, 36, 37.
These are all similar matters, Lordship.
Congratulations, Ms. Chaudhary.
So much.
Yes. What about the affidavit? Government. APSC. APSC has got no ruling.
He not supposed to appear in this.
Supposed to appear. Why not appear?
First of time being not.
Not worth it. You have not filed an affidavit till now. You are having an interim order, madam.
Yes, yes.
Do you want to file? Or you don't want to file?
34, 35, 36, 37, similar.
But Ms. B. Chaudhary. We'll say non-appears for the respondent. Then what?
Time being not.
Okay, Ms. Chaudhary, for the time being.
Yes, the readings are over. Well, the
No, we are hearing it today.
maintainability is the core issue.
That's the issue we will take up. Where is Mr. Lockhart? A reply to Aishan, na? Aishan. Mr. Lockhart. Yes, what is your ground?
Lordship, first of all, they have stated that Means there are-
Forget everything, forget everything. First, you get over one thing. There are two cases already filed in the civil, a title suit and a money suit against you. It's pending. I'm not going into the issue whether those were instituted prior to filing of this writ petition or after the writ petition.
Lordship,
Now,
in my
the case that you projected before me was that there is an institution which you were the accountable manager. Now, for some personal problem of yours, you required respondent number 5 or 6 to be the accountable manager. Now, the further projection you make is that because by that virtue, he is now trying to shift this college from here. Your college has two parts. One is the Gauhati University part and the other one is the Air Force maintenance. The maintenance part, he is trying to shift it to Orissa, and the license now is being renewed as of it is of at Orissa, not Gauhati. Now, but Mr. Blocker, you have handed over the license for a consideration. Why? Have you cancelled those deeds?
Lordship, that is the main issue, that during that period of time, I was going through a
Mr. Blocker, what you're going through is going through, but you have entered into a contractual relationship with someone that is holding the field. Until and unless that is not nullified by a competent court of law, we can do nothing because you have handed over everything to him. And that is the stand taken by the official respondents also.
Lordship, in that, they said that I have taken consideration. And they have instituted two suit. One is money suit, one is restraining, I should not enter to the.
Because you have yourself undertaken in your declarations that you will facilitate even transfer of the institution.
Lordship, yes. In that case, that money suit.
But we are not concerned with the money suit.
Money
We are
suit,
concerned whether this proceeding should be considered by this court.
Lordship. So agreement I have made. It is evident. Agreement to run the institute.
No, you have handed over the license also.
License handed over. It is not
And
sold.
also, Mr. Singha, you have also said that you will facilitate for transfer of the institution.
Lordship, yes, because this premises was rented premises. My premises was rented premises. I did not have any alternate arrangement during that period of time. I procured a land, constructed.
I'm sorry, this is
But-
not a case where we can come in. You will have to get this thing nullified.
Lordship, this agreement is not a sell deed. It is agreement to run the institute. I will, since it
The
is a
second party with respect to payment of consideration against the handing over of the approval license for running the aircraft maintenance college, the first party hereby admits and acknowledges the sufficiency of the consideration price. Nominee first party shall have no claim whatsoever on the said business with effect from the complete execution, and henceforth the first party is no way liable, responsible for the affairs in connection with the College of Aeronautical Engineering, AME Bharat. When this is holding the field, I'm sorry, we are not coming in.
Lordship, since they could not maintain the aircraft maintenance engineering properly, students are suffering. They will not maintain.
That's none of your business now. You have already handed over everything.
Lordship, it is
That
not
is
been
for the
told.
government and the respondent to look into.
Lordship, since it has not been sold, it is not
Mr. When
available,
you have
sir.
given up the complete corporate responsibility, you have given the corporate responsibility.
Lordship,
You have lost it. That's all.
Lordship, I have given.
And what is the title suit for? That is interference.
They are avoiding the service of notice, my number of attempts we have made. Now, my lord, since my lord, this is the position, service of notice, now it is standing for.
I'm not on that. Why did you go there? So what is that title suit for? What declaration?
Declaration, my lord, this position has been done. And my lord, and we also wanted the agreement to be, my lord, enforced. That has not been nullified till date, my lord.
That has not been nullified. It cannot be because that is agreement which is. And Mr. Locker,
Lordship.
this government also, the authorities have also, once they gave you that, then they withdraw. They said, we did not know the background. Now the background having come to our knowledge and these developments having taken place, we are not, we have cancelled and give it back to you.
Lordship, it is.
The only problem here is these 3 documents. That's all. Nothing else.
I will, Lordship may kindly give another date. I will just address it.
You will have to.
I will address it.
Heard Mr. B.S. Laskar, learned, petitioner in person. And also Ms. K. Fukan, learned CGC, appearing for the state respondents. And Mr. S. Chamaria, learned counsel, appearing for the respondent number 5 and 6. Mr. Chamaria has raised the issue of maintainability of the present writ petition. Mr. Bikram Singh Laskar has made his submissions. However, he submits that he be granted further. When?
Next week, Lordship.
Next week, not possible. Next week tied up, na? Undina pari diya thun. Khali thaka alop.
Because Lordship, date
18/5.
18/5.
You will not be here. When will you be here?
Next week onwards, next month. Anyway, Lordship, if I'm not there, I will engage.
No. You should be here.
I'll engage some counsel.
No, you be here. When?
Lordship.
I'll have it when you. Mr. Locker, we have seen you arguing.
Lordship.
See, these are issues which you have to meet. These are legal issues which I'll have to address. So I'll require a
Lordship,
input from you.
Before 7th of this month, next month.
7th will not
Before
because
7th.
all tied up. Many matters are.
Lordship, another problem, if they, I have filed one IA.
We got it. We will undo everything. Don't worry about
Lordship, if they take admission, another
that.
multiplicity
Admissions
of-
will come back to you.
Lordship, there will be problem because they will take admission a student of Odisha.
You are
those
here
would-
on 7/5.
6 would be comfortable if Lordship.
Like a board,
permits.
isn't it? 5, 6/5, 2020.
Deeply obliged.
Please don't take that. I have made up a view, but this is the query that you have to meet now.
In this case, the
Reinstate him back in service and proceed against him departmentally.
Yes, my lord. Follow the lordship. That 10 onwards, there is a specific statement in the government. Just like to. I'm only for the university. If you will. Kindly peruse para 4, thereafter page 6. Page 6. Parties, my
Yes. The proceeding, department proceeding was instituted against you. Yes, Mr. Das. Time being. Okay. Mr. Patori, give him a copy of this.
I have given.
Give him also. You can
This
take
is
this.
already addressed to them only.
No, I got it. Give it to them
Yes, no.
so that he gets that instruction. We'll have it at 2. We have fixed the matter. Thereafter, we'll take up this.
Yes.
And that criminal case, you're getting no benefit because that is a case which the informant, I don't know why, the informant did not adduce any evidence. So the court closed it. That will not give you. We'll make it very clear. And if the documents are forged, latest Supreme Court decision is against you. T.T. Vinod Kumar. Mr. Bhaiya, congratulations.
Thank you, my lord.
You have got it? Got the payments?
Yes, today morning, my lord, I got my payment, my lord. Nothing left except, my lord, the prayer at portion B, my lord. That with regard to this unnecessary delay, where
Oh, that
that is there.
all is well, that is ends well.
I leave it to your lordship.
But Mr. A.K. Bhaiya, learned senior counsel, assisted by Mr.
Account.
Account, learned counsel for the petitioner. Also heard Mr. B. Kaushik, learned standing counsel, secondary education department. Director, we can't say department. There is no department secondary education now. Learned standing counsel, Department of School Education. Also heard Mr. C. Borua, learned standing counsel, Accountant General, bracketed A&E Assam. The present writ petition was instituted by the petitioner, praying for a direction upon the respondent authorities to release to her pension and pensionary benefits with effect from the date when she had proceeded on superannuation. Also, the matter was considered by this court on various dates, and thereafter the respondents, on a resolution of the disputes existing in the matter, had submitted a proposal for release of the had submitted a pension proposal in respect of the services of the petitioner to the Office of the Accountant General, bracketed A&E Assam. The said proposal was processed by the Accountant General and a PPO. PPO issued? It is by direct. Oh, Director of Pension.
Yes.
Submitted to the Director of Pensions Assam. When was the PPO issued, Mr.
Affidavit, sir. They have filed an affidavit, my lord, wherein, my lord, this was withheld because of non-submission of
When
that.
was the anything to show that you have received the money now?
Yes, my lord, I have received instruction that can be recorded, my lord. Today morning, they have my client have received the amount.
Received the areas. Earlier, the PPO was issued to her.
My lord, provisional pension was paid.
Huh.
And
When was the final pension PPO issued to her?
final pension PP, my lord, the amount has been received by today morning, my lord.
So there has to be a PPO. Amount will come from the কেনেকা লিখিব এইখিনি কাটি দিম hurt sub থাকিল. The petitioner in the present writ petition has raised a grievance with regard to non-finalization of pension and other pensionary benefits from the date of her superannuation. So, in terms of the directions passed by this court in the present proceedings, the matter was further processed by the respondent authorities, and a pension proposal in respect of the petitioner was forwarded to the Director of Pensions Assam on 27/2/2026. Saptara. Mr. A.K. Bhuya, learned senior
PPO
counsel.
number
appearing-
is 17/3/2026, man.
PPO.
PPO.
Learned senior counsel appearing for the petitioner submits that the pension payment order in respect of the petitioner was issued on 17/3/2026. He further submits that the arrears as receivable by the petitioner of her pension has been since credited in her account.
Yes.
So accordingly, Mr. Bhuya fairly submits that the pension and pensionary benefits receivable by the petitioner has been already deposited in her account, and accordingly, the grievance of the petitioner to the above extent stands redressed. However, he submits that the respondents for the delay involved is to be made liable for paying interest. Also, should be made liable for payment of interest on account of the delayed payment of the pension and pensionary benefits. Also, this court has appreciated the submissions of the learned counsel for the petitioner. However, considering the reasons for which the delay in payment of the pension and pensionary benefits have so occasioned, this court is of the considered view that it is not a fit case wherein the respondents would be required to be saddled with the interest component for the delayed payment of the pension and pensionary benefits to the petitioner. Also, the pension and pensionary benefits having been authorized to the petitioner and the amounts involved being credited to her bank account, this court is of the considered view that the present writ petition has been rendered infructuous, and accordingly, the same stands closed.
Deeply obliged, my lord.
Content के-
58, yeah, definitely. Filing melon during the course of the law.
What is your stand?
So the basic stand, melon, the GIS and the leave encashment, it was sanctioned pursuant to, because the post was adjusted in 2002. Then the, and accordingly, melon, the pension proposal has been also uploaded in the Kregata portal. It has
Pension has been sanctioned.
was uploaded in the Kregata portal.
Now, what happens after the Kritikata?
It is the pension department.
What happened? When was it uploaded?
Was 24/8/2023.
23. For the last 3 years, what is the department doing?
But thereafter, the principal, my lord, he had to submit the paper, some papers, service book and the others, my lord, to the director. And
So had he submitted it?
no, my lord, it was, there were 3 letters to the principal, my lord, written. to the
What
principal.
proceeding have you instituted against the principal?
Now, my lord, it has been received And he has been receiving now salary from the pension from 4/4/2020.
Regular pension. Yes, madam, you are getting regular pension.
Lordship, I have no instruction, like fix at two, Lordship.
As prayed for by the Learner Council for the parties, registry to list this matter again after 4 weeks. What is this pension matter? You don't have those facts in your hands.
Lordship, my senior.
Good, go, you suffer, no problem. 2 weeks, go. This is not done. We'll not appreciate this. You're a seasoned advocate now. You have put in enough practice. That facts should be in your fingertips. Mr. On the next date of listing, as the Learner Council for the petitioner does not have any instruction with regard to the finalization of the pension of the petitioner, Mr. Kaushik, Learned Standing Council, Secondary Education Department, shall apprise this court about the developments taking place in the matter. Madam, next time don't come like this. Come prepared.
So this matter, my lord, we need further 2 weeks time to file our reply, Lordship.
On the prayer of Mr. N. Sharma, Learned Counsel for the petitioner, further 2 weeks time is granted to the petitioner to bring on record a rejoinder to the affidavit filed by the respondents.
Deeply appreciated.
No time being today. Yes, argue.
Lordship, we are filing affidavit in reply today.
It is submitted by the Learner Council for the petitioner that a rejoinder is being filed today to the affidavit filed by the respondents. Accordingly, a registry to list this matter again after 2 weeks. 2 weeks or 3 weeks, go idea, for admissions for 3 weeks along with this said rejoinder. No dates. 2 weeks. Today was the date. Today was the date you took up a plea of maintainability. We are ready to hear you on that. We can't help it. We thought that he would be here. He's on some other legs in some other court. Second half. Second half. You get your rejoinder.
Bless them.
All transfers in Morigaon. Morigaon, Nagaon.
Okay.
Huzai, nearby. First posting out of that place. Have you joined?
No, no.
There is an interim order.
Yes, sir.
Sometime that if your lordship may recall, similar petitioner came before this court by 6 petition challenging it inter-district transfer, which was in the first stage itself state. Later on, he was asked, he didn't join that, but he was posted in the headquarters of the particular district. After that, the petition and contempt petition were withdrawn. The second petition challenging
Same petition.
same petition. He has never even went out of the district. I mean, he didn't comply with the transfer. Earlier also, here also.
Okay, where is your affidavit to that effect?
It should be a file.
File it.
Yeah.
Okay, that is. Yes, Mr. Sukya.
Your Honor, petitioner basic grievance is that your lordship may see page 58, where it says that normal tenure in a place is 2 years and within the district. So in exceptional case, before 2 years, that can be transferred with the permission of the committee and.
But you come to clause 11.
11, yes, and also commissioner can also.
Are you
transfer.
alleging malafide against the commissioner?
Yes, there is a malafide.
Where is that?
Because
malafide? Who is the person who is?
Because
Who is
your
subject to
lordship,
that malafide?
because that malafide, if we go to see that malafide, then we have to see the antecedent of how they come to this order.
Malafide,
Yes,
you
Your
have to
Lord.
prove
Your,
that.
yes, sir.
Against whom are you alleging malafide?
Yes, because your lordship,
There is no name
personal
by party
malafide,
by
but
name.
the process.
There is none by name here.
Yes, no personal, there is no personal
That-
malafide. the process.
You can't have institutional
Person,
malafide.
because they are in the
Bias.
guise of this exigency of service, they are trying to transfer him because as a punishment, Your Lordship. Why I am saying that, Your Lordship may found.
Because there is an allegation against you.
Yes,
They have not proceeded against that,
yes,
but they have transferred you.
yes.
Okay. What is the allegation against him?
We have filed our affidavit that this is a routine transfer.
No,
See, the
you have
way-
said that there was allegations against him.
If that was by an instruction, but that we are not relying on, we are relying on the affidavit.
Why you have put it on the affidavit? Somewhere I found
The affidavit, there is no regard.
Now in the affidavit, they are not mentioning that.
that the earlier written instructions. That
Yes, they have said. So, Your Lordship may see their conduct. Earlier also, they are trying to transfer him with the guise of that exigency of service. Then petitioner came before this honorable court, and honorable court has stayed that order. When that court has stayed that order, they are trying to satisfy their ego and try to manipulate that order. They have passed another order whereby they say that we have complied with the order of this honorable court and stayed his order. But on the copy section, they said one line that no work should be provided to the petitioner. Then Your Lordship.
I considered this.
Yes, Your Lordship will issue the notice, and against the notice, they come up with the direction that they have now abolished that clause, and therefore he may continue, and therefore the petition itself has nothing to do. There is nothing in the writ petition also, so we have withdrawn on their submission, Your Lordship. Again, after immediately they have passed this impugn order of transfer, Your Lordship, on the guise of this exigency, because this as there is a in normal course there is a tenure of 2 years and within the district. So when this is not done, it is an exceptional case.
Huzai district.
Yes, Your Lordship.
Huzai district. How long were you there?
But on the last years, he has been transferred thrice, Your Lordship, within the year.
Within the district.
Within the district.
Those are now gone. Only this is left now.
But
This is
because the
third
normal course is that their post should be transferred within the district.
Okay.
In
So
exceptional.
you don't want to go out of the district.
No, I don't have that issue. From the beginning
No,
of
you want to
joining.
go out of the district. You have any issue with going out of the district?
No, because Lordship.
And you're not
recently-
working. You're not working now.
Yes, I am.
Where are you working?
This present place of posting, Your Lordship, there's a Binaka Kandi.
In Huzai itself.
Huzai itself. Because Your Lordship, one.
Where is the records?
The records are not
Get the records. We want to see how you have passed this order.
very, and is that.
You forget your stand. We want the records. Any problem in giving the records? You are claiming some privilege? Tell me. We'll say. Mr. Haddi, learned counsel for the parties at some length. Mr. Ghosh, learned standing counsel, Panchayat and Rural Development Department, to produce the records wherein the transfer of the petitioner. Where is that order?
Page 29.
29.
29, 14/3/2020.
Wherein the from where this is a e-file. To produce the note sheets leading to the issuance of the order dated 14/3/2026 impugned in the present writ petition, right? This is the order. They said records be produced on Friday 15. No, Friday. Oh, no. 6 तारीख है तो record है 6th. Interim order passed earlier to continue till the next date of it. 5,
maybe
7, 8, 5.
Obliged.
Okay, admission fake admission. Orders kita check koi.
Wait, please, Lordship. Lordship, there is a confusion in item number 16 and 13, Lordship.
16, item number 16, what is that? That review matter.
No, Lordship. item number 16 is
13 is
repetition.
the review.
13 is review matter.
Review, there was none appeared.
Actually, power has not been given, Lordship.
We said none appeared. List after Kiman, 6 weeks. And in item number Kiman, 16. Oh, it took 3 weeks, Koidia. 16. Both 3 weeks.
So may kindly peruse the order.
You have got it?
No, my lord.
Yes, who is appearing for the respondents? Forget 6. You are for the 6 is the
Already filed my affidavit, madam.
which department? This is item number 40.
40, my lord.
You're not there, Mr. Professor. You're not there.
He is for 41, my lord.
41, 40. Who is for 40? Department of Elementary.
Elementary education, my lord.
Nobody is appearing.
Nobody is appearing.
There are advocates named here. Mojumdar, Katoniar, Fukon. Okay, we'll direct them to appear then personally. How much we can't wait for their convenience. There are around 7, 8 advocates. I forget the first 2. But the others, somebody should be here. This is the casual nature. What should we do, mister? Some let them come. Let's see what happens. 5 minutes. Okay, 5 minutes. 5 minutes, Bishop Malika.
Lord, in this case, my lord, the dusty was permitted.
Forget your dusty. Who are you?
I am the
Moni
vice-
Sarma,
second
Gita Sarma. Moni Sarma, mother of Kuho Sarma, mother of one daughter. Then the daughter becomes sister's son, daughter. And then the 2 other sons come up. First wife dead. Secondly, first wife divorced. Now the first wife has been served with a notice. We are going to impose cost on you.
My lord, what happened?
Or you
in
go
this
before
case?
the civil court, establish your right that you are the wife.
Because of marriage with the petitioner, my lord, husband was.
There is a
removed from the
divorce
service.
proceeding, 94, no material.
No material.
These are all hypotheses. Somebody is dreaming something. And then a writ petition is made out. Will
What happened?
not permit you to.
My lord, by the village head, my lord, the divorce was
Show me a Hindu marriage can be divorced by
That is
it
true.
cannot be.
That
So
is-
bigamy, that order,
my lord, because of bigamy only.
Mr. Soikia, that bigamy order stands. That means what? There are 2 wives.
Yes, my lord.
Huh? Now the first wife declared in the record is from Gita Sharma.
Yes, ma'am.
Subsequently, Gita Sharma becomes mother of 3. Subsequently, he is imposed with the penalty. Thereafter, he comes up. No, Moni Sharma actually is Gita Sharma. And the sons are also named with their nicknames.
Yes,
Suresh, Santosh, and then no, their names are Manoj. Raises a big doubt. Will not entertain this. You go before the competent civil court, establish your right that you are Moni Sharma, wife of late so-and-so. There is no other wife available. Guys, this is a petition which raises
yes,
a lot of doubt.
Yes, madam.
And your affidavit in reply goes another way around.
Reply
Now a
is the-
decree of divorce also comes up, wherein their statement is husband's that she is dead in 85. Then he subsequently comes out, no, I have filed a
Lord, the-
divorce. I'll get it.
I have gone through the, my lord, statement, my lord, the affidavit in opposition.
from the affidavit in opposition, my lord, I actually told my junior, my lord, he was his case, my lord, not to pursue with this case.
You should not. This will create a lot of problems for you because it's a doubtful case. Mr. Soikia, withdraw it. We'll give you liberty to go before the
conduct of the late husband is not, my lord, appreciable, man.
Huh?
My lord, the conduct of the late husband.
Late husband's conduct, your conduct also. And there are 3 wives actually.
Maybe, my
Yesterday
lord.
night I found
Maybe,
3
my lord.
wives.
Maybe, my lord.
Lakshmi Devi is also there. That Lakshmi Devi gone into oblivion in the meantime. You want to withdraw it or we'll dismiss it with we are dismissing this petition. KD Sharma we are bringing.
Lordship may dismiss it, my lord.
Okay. But Mr. Soikia, I took a legal, but we are imposing cost.
In that
Every
case,
cost. And that we will do.
In that case, I will withdraw, my lord.
We'll impose. We'll dispose it. Why should you withdraw? Heard Mr. K. Parasar.
Lordship, I will withdraw, my lord.
So and so. Mr. The present writ petition, in the present writ petition, the petitioner has claimed for being authorized pension and pensionary benefits, family pension in pursuance to the death of her son, of her husband, Naturam Sharma, who was an ex-employee, who was a member of the Central Reserve Police Force and was imposed with a penalty of compulsory retirement on the ground that he had committed a misconduct of marrying more than once during the lifetime of his first spouse. The materials brought on record does not raises a dispute with regard to the very identity of the petitioner as the wife of late so-and-so. Further, there is also a dispute with regard to the status of the other wives of the force personal, Naturam Sharma. Also, in view of the above developments, about position emanating in the matter, Mr. I. Soikia, Learned Counsel, appearing for the petitioner, submits that he be permitted to withdraw the present writ petition with liberty to the petitioner to approach the civil court of competent jurisdiction to establish that she is the only wife of late Naturam Sharma, ex head constable / armorer, ARMORER, Central Reserve Police Force, and the marriage with the other projected wives was never solemnized by her deceased husband. Also, basing on the said in view of the submissions of the Learned Counsel for the petitioner, the present writ petition stands dismissed on withdrawal with liberty to the petitioner to approach the court of competent, approach the civil court of competent jurisdiction for establishing her claim for being authorized family pension by the respondents here.
Obliged, ma'am.
Yes. Now, where is the interest component? 12%. 50,000 paid.
The last occasion, my lordship, 10/3/2026, lordship has clarified, my lord, that
Yes. Wait. Where is that exact direction for 12%, Mr.
My lord. That order loss will find at page 14, my lord. Page 13, my lord. Just from page 13, paragraph 7, my lord.
Okay, what is this?
For the pension.
We are not concerned with the pension in this case. I'm only concerned with the payment of 12%, and it was clearly set out in the earlier order. There is a direction for payment of 12%. You have released the areas. Where is the 12%? No, not today. Or I'll have you, because we have said, if there is thing, we will be left with not institute contempt proceedings. Have them here by 2 o'clock. We will drop contempt proceedings. Enough is enough. Done. What to? We want them here. You ask your commissioner, secretary, and your director, who is there? Principal Secretary, Finance, Director, Elementary Education. Or you have not made the new ones, party, not
My lord,
substituted.
New one has been made party, my lord.
Where?
This one was 6, my lord.
Filed an additional cost title.
Yes.
This order, what were you doing after this? Have you communicated this order? Communicated. No response. That's what they show. We'll see how they have to respond to these orders of this court. We'll see. 2 o'clock. Oh, don't worry, I'm here till 7 o'clock. I can get it done before 6 o'clock also. 2 o'clock, I want it. Why this 12% was not released to you? And if they are not interested to give you instructions, ask them to directly, maybe they don't like you all, ask them directly to come here and interact with us.
Last occasion, my lord, the court has directed to complete the instruction, my lord.
As per my instruction, towards compliance, the petitioner's case has been placed before the state level committee on 3/4/2023. They're preparing the minutes for some.
So for the last 2 years, what were you doing?
There was regard to the business.
Mr. B. Kaushik, Learned Counsel for the respondent, submits that the petitioner's case has been placed before the state level committee on
State level scrutiny committee.
State level scrutiny committee on
3/4/2026.
on 3/4/2026, and the decision thereon is awaited. So this court had wide order dated 10/1/2024. With the following direction. Page 12, 8-8. So, from the materials brought on record, it is seen that a certified copy of the order was furnished to the director on 28/2/2024. Also, the director on the next date of listing shall file an affidavit. Director, the respondent number, the respondent here shall file an affidavit as to how the matter was processed after the certified copy of the order dated 10/1/2024 in WPC number 6329/2023 was placed before the respondent. So the said affidavit be invariably brought on record by the next date of listing. So in the event the affidavit is not brought on record, registry to list this matter again on 15/5/2026. Mr. B. Kaushik shall communicate a copy of this order to the respondent for compliance.
Obliged.
My bless your lordship. My lord, kindly let this matter be taken after some time.
Please, my lord, number 6. Come to the.
You are?
I am Horace, one of 5 men. I have also filed one objection to the. That is not on record. 24. File this. 21/4.
You are for 5.
5.
Your thing is closed. Nothing. What do you have to got to do here?
One statement is there, my lord, they're saying that he come to know about the order of passed by this court in 2025, whereas his salary was stopped in 2023.
Who?
The review petition by this court order, my lord.
Review petitioners only please that in 2019 he had brought this matter that it is not you, but the respondent number 7 who is to be provincialized, respondent number 6 who is to be provincialized.
Taken into consideration by the
But
court.
that was not taken into consideration by this court. He had filed an affidavit also. To that extent, he is saying that once I have done that, why are proceeding against me?
The affidavit was not filed by him. The petitioner itself brought that letter.
No, there is an affidavit by the Rafiqul Islam.
That is not.
There is an affidavit I've seen. Seen the office note dated 21/4/2026, which reveals that the service upon respondent number 6 is not complete. So, petitioner to take fresh steps for service of notice upon respondent number 6 by way of speed post and also by way of dusty mode routed through the registry of this court. He is in the same school, give him dusty. In the event the steps are taken by way of dust, in the event the service of notice upon respondent number 6 is affected by dusty mode, petitioner to file an affidavit to the said effect. Registry to list this matter again on July 25, 2026.
In these two.
Complied with.
Currently, your lordship, but only difficulty is this, your lordship.
So you wanted, you wanted a retrospective effect.
Lordship.
Pay protection. That pay protection
Pay
has been
protection in the order they have given, your lordship. Later they have complied, but the spirit of this.
Fine. Letter means that
No, we'll have
consequential release of money.
My only
Fixation.
apprehension is, your lordship, that I will again have to come for the arrears, your lordship. That's, they have not calculated what will be our arrears from 2016 onwards.
Mr. What do you say about that? They'll be given. You are giving an undertaking to that effect. We'll record.
That is not my undertaking.
Then.
That's
you get your undertaking. Whether that fixation has been made in pursuance to that. Why should we pass an order here? Okay. Lekha. Had Mr. S. Pothakur, learned senior counsel, appearing for the petitioners in the above noted contempt petitions.
I am in 45.
Also heard Mr. A.R. Tabilda.
I am in 45 only.
45. Oh, Khali 45.
Issue same.
Item number 45. W in contempt case number 258/2025. Mr. Pothakur has submitted, Mr. A.R. Tabilda, learned counsel for the petitioner, by placing on record the instructions received by him, has submitted that the directions passed by this court void the. There are two orders or the same one order?
One order, your lordship.
One order.
One order. Covering
okay.
two.
Void the order dated. Judgment and order dated 16/5/2024 in WPC number 1162/2023. No, no, no. Divyojyoti is different.
3770.
In WPC number 3770/2021 has since been complied with. Also, he submits that the pay protection as directed has been granted to the petitioner, and further and further the services rendered by the petitioners with effect from their date of initial appointment has been now directed to be reckoned for the purpose of granting to them benefits under the Career Advancement Scheme. Also, Mr. Bhatthakur, Learned Senior Counsel, has submitted that although the said orders have been passed, the respondents have not prefixed the pay and allowances of the petitioners in terms of the pay protection granted to them.
Lordship, from this month, your Lordship, April, it was refixed.
They are getting it, so nothing is there.
Lordship.
Mr. Bhatt submits, the said position is not disputed by the Learned Counsel for the petitioners. Accordingly, the directions passed by this court having been complied with, the present contempt petition stands closed. Second to Eke Mariva, Ali repetition number. Who is appearing for the second one?
SS Goswami, your Lordship.
He is
Learned
not here.
Counsel.
It's between you and me.
Lords.
None appears for the
If
petitioner.
some observation about arrears can be made, your Lordship. Lords.
None appears. His name is not shown.
44 in item number.
Shown. Mr.
He
Goswami
normally
is not
remains
here.
present, your Lordship. He normally remains present
he
for this
normally is
case.
here. Because none appears for the petitioner for the ends of justice. Budbar ba Biraspati ba log idea.
Lords.
44.
45 close.
45 closed.
Deeply obliged.
I'm praying for indulgence, my Lord. Whereas it will be reached in the second half. It is on my part in the second half. My friend is for the. And I received an instructions below.
This was for furnishing a compliance order today. Is that compliance order will free you now only?
No, my Lord, the compliance order in that case, my Lord, it's not exactly a compliance order.
We don't know anything exactly. We want exact.
My Lord, this is what we presently received, my Lord. And the affidavit executed by the mother of the petitioner, my Lord, that is with the government.
That's what you said that day, that you are passing. You have already come to a conclusion that the petitioner is not this daughter of that your employee.
I'm submitting on this point. And let we have two ways to find it out.
We don't know two ways. We only know one way.
We should for a while. I'm just submitting with your Lordship. One, that affidavit that has been executed by the mother of the present petitioner. In that affidavit, my Lord, she did not mention the name of Nazira Khatun. That original copy of that affidavit is with the government.
We can't help it.
I'm coming to this, my Lord. Second, my Lord, we have taken steps, my Lord, writing a letter to the DC Dhubri to find it out whether she is she was the daughter of Mr. Swenson. This has taken some time, my Lord.
Mr. Tamuha, last date you had made a submission on instructions that you have come to a conclusion that she is not the daughter. But you did not pass an order.
My Lord, the conclusion is this, my Lord. Conclusion was based on that affidavit.
Okay, sound dear.
Conclusion was based
Item
on
number
that affidavit.
60. Okay, we'll take. You are there?
Present,
Yes.
my Lord, we are bringing the affidavit.
Mr. Dr. A. Chamua, Learned Counsel, for the sole response submits that materials coming on record have revealed that the petitioner is not the daughter of so-and-so, who was an employee. Contends that a default had occasion in the matter in the sole respondent or in the managing not passing compliance order on the basis of materials coming on record with regard to the status of so-and-so. He submits that he be granted further time till so-and-so, by which time the process involved for compliance of the so-and-so shall be completed and the compliance report shall be placed before this.
Right, 200%. That affidavit
Where from this conclusion?
Why did you
read? Then you make a submission that she is not the daughter. You have not reached that conclusion till now.
Original copy, we have a photocopy. That is not proper.
Mr. Counsel, we are not worried. We are not concerned. We only want a compliance of an order which was passed on 23. Ask your managing director to be here. We'll see why it is being delayed. 3 years is too long time.
I appreciate, my lord. I appreciate that, my lord. But it is not a case that we have not done anything, my lord.
Where is it? I don't have it
That is
before
what I
me.
bring on.
You were supposed to bring it on record. You made this order was passed.
My lord,
I have
sometime-
utilized my stenographers. I have utilized my time basing on your submission.
Most I can do, my lord, I can apologize. Everything raised on your lordship wish, my lord. I bow down to this, not arguing for a while that it is not a fit case for taking a proper action, my lord. But when we are doing something, my lord, let us have it.
Mr. You get me by 2 o'clock what you are doing. I'll condone this.
The problem is this. I have a puja in Kamakha, so at second half, that is why I was disturbing your lordship at this hour.
On the prayer of Dr. A. Chamuha, who submits that he would place on record the manner in which the respondents have dealt with the Mr. A. Chamuha submits Dr. A. Chamuha, who had on the this court basing on the submissions of made by Dr. A. Chamuha had recorded the following observations. A to A. Jawab order. Mr. Chamuha submits today has submitted that the said observations have been made erroneously inasmuch as a final decision in the matter as to whether the petitioner is the daughter of late Abdul Jalil Mia has not been arrived at. Also, he submits that the said decision is still pending. The managing director, ASTC, shall file an affidavit. The respondent, that means respondent, that is the managing director, ASTC, shall file an affidavit as to
that person is no longer here.
the present managing director, ASTC, shall file an affidavit in the matter and therein disclose as to the manner in which the compliance of the directions passed by this court wide order dated 13/2/2023 in WPC number 5463/2022 was being so processed after a certified copy of the said order was placed before the said authority by the petitioner wide communication dated 13/3/2023. Also, this order, court, the said direction is passed inasmuch as although 3 years have lapsed in the matter, there is no material brought on record to demonstrate as to the manner in which the respondents have processed the matter for compliance of the directions passed by this court. Also, registrate to list this matter again on Azikiman 27. 5/5/2026. The affidavit be brought on record by 4/5/2026. Mr. Chamuha will not take these things very lightly.
I appreciate. I am informing regularly to the department, my lord.
You move out, let the person come, we will deal with him. You move out.
This date I'll do everything.
You move out. Or do you want us to do it? Record it. I'll record it if required.
I'll do it. Okay.
Just taken with the last.
It's in the office note dated 17/3/2026, which reveals that the notice taken by the petitioner was so taken in respect of respondent number 6 and not in respect of respondent number 7. So they said said issue had arisen in as much as in the array of the array of respondents, there is an error in the numbering of the respondents in as much as the Director of Agriculture, Assam, Khanapara, who is being arrayed as respondent number 2, in as much as while the Director of Agriculture, Assam, has been arrayed as respondent number 2, the Director of Pensions has also been arrayed as respondent number 2. However, the said numbering is found to have been rectified in the CIS data. Accordingly, the petitioner to file an amended cost title rectifying the said numbering of the respondents of the authorities arrayed as respondents in the cost title of the present writ petition. The said amended cost list be filed, cost title be filed within 2 working days from today. Thereafter, the steps taken by the petitioner for service of notice be so deemed to have been so taken in respect of the respondent number 7, that is Milan Nessa, and the notice be accordingly sent by the registry to list this matter after 4 weeks. Just file a thing because it's already rectified. You just rectify it.
Right. My lord, recently, my lord, meeting was held in the education department along with the registrar of the Gauhati University regarding the instant meta. So, as per the minutes, some queries were made, and we have responded.
But only tell me, how can we, in a disposed of matter, how can you reopen it by way of an interlocutory application?
My lord, since some clarification is required. Earlier,
there is no clarification required.
My
You
lord,
have filed a review. We have answered that review.
my lord,
Now, how can you file a interlocutory application on this?
lord,
Not for
in the
correction,
original
it's for
writ
change.
my lord, in the original writ petition, my lord,
You satisfy me, Mr. Fukan. How can we entertain this interlocutory application?
my lord, we'll file
The latest decisions are also on record of the Supreme Court has also come. That in a disposed of matter, you can't reopen it with a,
my lord,
some corrections are there.
my lord.
Fine, we understand, but not for amending the order.
No, my lord, I'm not for the amendment of the
Any
earlier order.
clarification, I touch it, it will amount to an amendment. How can I do it?
We'll file an additional affidavit regarding that minutes and the query.
First, tell me about this
My
interlocutory.
lord, in 2020, my lord, that order regarding.
Mr. Fukan, I am on a very small point.
My lord,
Whether this interlocutory application is to be entertained. It is not to be entertained.
my lord,
Because it's already a closed matter.
my lord, since it's not for modification of earlier order.
It's basically
My lord,
the clarification if I give, it will tantamount to modification of the order.
No, my lord, may I, my lord, take your lordship to the earlier order, my lord. Dated 12/12/2024.
Mr. If you come to the prayer,
My lord,
you are asking us to modify that order and make it in tune with the orders passed by the Honorable Supreme Court and this court. 1:2, that ratio is to be followed. How can that will amount to touching the merits of the matter?
my lord, may I take your lordship to page 56, my lord, the earlier order. The last pyramid. Page 56. After
This is
hearing,
the original order.
my lord, it's an order in the IA.
No, it's an order in the review, I suppose. Yes, it's the order in the review.
First writ petition order, then review petition order, then this IA order, my lord. This page 56.
This is just a simple clarification.
My lord.
But what you are trying to do now is going a step further than that.
No, my lord, since my lord, the first order was for giving time scale of pay.
I'm not having the first, I'm not considering the first order.
Then my lord,
Neither the review order.
That
I'm
order
only
was,
on the point whether a interlocutory application would be maintainable, Mr.
Milord, Milord, may I place those Supreme Court's judgments, Milord?
Yes, please.
Milord, regarding that modification, Milord, Milord, I am not for modification.
What would be the effect of this?
Milord, since Milord approval, the entire matter has been sent to
That
the
you had
approval
already come up
process.
before this court. This court
Yes,
has
Milord.
clarified. Now we can't go on clarifying so that the contempt gets delayed.
Milord, the contempt has got, Milord, infructuous, Milord. Since, Milord, the order dated, Milord, 12/12/2024, the contempt petition was of 2020 and of 2022. It is prior to that approval process, Milord.
This court had made that clarification with the stipulation that we are not interfering with the earlier orders passed by this court.
Yes, Milord. I am not for that, Milord, for interfering the earlier
You
order.
just satisfy me first
Milord.
on the point whether
Milord.
this interlocutory application would be maintainable.
Milord. Since, Milord, it revolves around the merit of the case, Milord. First, Milord, that time scale of...
That's what I'm saying, Mr. Whether I can consider the merit in an interlocutory application.
Milord,
You go up on appeal.
merit regarding, Milord, that admissibility of this interlocutory application, Milord.
Admissibility
Milord.
of interlocutory application in view of the litigational history as well as the nature of the relief sought for.
Milord, earlier, Milord, Higher Education Department has been directed to bestow, Milord, grant prior
You can
approval.
come to page, the prior portion, page 21.
May I read, Milord? In view of the aforesaid facts and circumstances, this honorable court may be pleased to admit the instant application and clarify suitably, it's not modify, Milord. The instant matter as regards due processing of the private respondent number 4's engagement on fixed pay as assistant teacher as per existing laws of the land as laid down by the Honorable Apex Court and the courts thereunder, including this honorable court, and or may be further pleased to pass such
So what do you want us to do?
Milord, that chronology of events, Milord.
Okay, I accept your prayer. I'm allowing this. What would be the effect?
Milord, then, Milord, that approval process, Milord.
Now, what would be the effect on the original order?
Milord,
the original order which says that she is a compassionate ground appointee, she is entitled to get it from that day. Now will have to be read that she will require a regularization.
Milord, that has been modified in the review petition, Milord. First, that time scale. Then in reviewing petition orders, Milord, may I take your lordship to that order in the review petition, Milord, page 31 to 34. Earlier, that approval process was not there. Slightly crucial, Milord. In the writ petition order was for giving time scale. Then in review petition, page 31 to 34, may I read, Milord? Page 34 is the relevant portion, Milord.
You come to page 32.
Milord.
That para 7 has been quoted. That is the review sought for.
Milord. Then, Milord.
Then come to para 4.
Milord, may I read that para 2,
That we
Milord?
have got it. You come to para 4.
It's regarding, Milord, payment of time scale. But now, in the last portion, Milord, in the review petition, though it is regarding payment of the time scale, but it has been sent to the government.
Mr. Here only
for
I get
approval
it.
process.
I only get it here that it is the secondary was there. It should be the higher. And now both have been directed that you do it. Much only is the clarification. Whereas the original order and para
Milord, in
7.
the IA, Milord.
I'm sorry.
Finance department has been, Milord, robbed into me.
You go up on appeal. You're not touching this. We are rejecting your application.
Milord, since, Milord, in the review petition,
the
matter has
the Supreme Court orders, don't worry. But
Milord.
why this is not maintainable?
Milord. Since, Milord, there are two aspects. One, regarding, Milord, that Devdatta Tiwari case judgment, Milord, regarding compassionate appointment process. And second one, regarding that...
You are not in a position to rake up that issue now. That is gone. That is finalized. Devdatta Tiwari and all will not come here. Because that final imperative of this court has been given.
Since this honorable...
Because the logic reasoning of this court was she was appointed basing on a compassionate grounds. You have now tried to rake up the issue that no, her mother was working at that point of time, so she was not in a need of a, that cannot be gone into at this stage. The only forum which can now consider that is the appellate forum.
That is why, my lord, in the review petition, order was given by this honorable court.
It was only
send
that
it to the-
secondary and higher secondary will together do it, not the secondary alone.
Secondary higher, along with the, in consultation with the finance department.
Be that as it may.
So, my lord,
Let
that
them
approval
do
cannot
whatever it's
be,
there. That we will see in the contempt petition.
that approval process, my lord. it's
Because
a-
I dismiss this, the contempt will come up. I'll handle the matter there.
My lord, since, my lord, in review petition, the entire matter has been sent to the
Okay.
approval process, my lord. My lord, may I
Anything
submit,
further?
may I submit, my lord, regarding that approval process, my lord?
We
This
don't,
honorable court has not
we are
directed to
not
blindly.
concerned with that. We are not concerned with that. We are concerned with the maintainability of this interlocutory application.
This
Have
honor-
any submissions to make on that? You can make.
My lord, this honorable court has not, my lord, directed the respondents to, my lord, put signature in a dotted line blindly, my lord. Since approval
Fine, don't do
process,
it. Don't do it.
so that is why, my lord, that is why this clarification, my lord. Whether
This is
that-
not the clarification. You are saying that the clarification is kindly modify your order in tune with the Supreme Court and the High Court orders, which we refuse to do because it has already been held. If that order is bad, go up on appeal because you have already filed a review. And the review para 7 was not modified. It was upheld rather.
My lord, since, my lord, entire matter has been sent to the approval process, and before approving,
You go up on appeal. If that is an illegal order, go up on appeal. Get it quashed. Then the contempts also go. I can only protect you to a certain extent that I can give you some time.
my lord,
That I'll ask the contempts to be listed, say, after a month. In the meantime, you take up whatever you want to do. But this we are not entertaining.
I pray for some time, my lord, at least, my lord, 10, 15 days time to get the instruction. Possibly, I'll have to withdraw the petition.
You have to withdraw, you withdraw it today. But I'll protect you
But
in the
it's
contempt
still-
petition. I'll not allow them to make their submissions today. I'll give you a breathing space. Don't worry about that.
The matter may come up on 15th, my lord, and
I can't read this file again. Too cumbersome. I've read it once. That is enough.
lord, my understanding of that review
Okay,
order, my lord,
why don't you contest it on merit? You make your submission that this is maintainable. We will pass orders. No problem.
today at least some time may be given, my lord.
See, I understand time to be till 4:30. If you want days, okay.
Days, my lord.
Okay. Mr. PJ Fukan submits that he be granted further week time to make his submissions with regard to the maintainability of the present interlocutory application. It is to be noted that the present interlocutory application seeks to modify the orders passed in a the final orders passed in a connected writ petition, also, which in the considered view of this court is not maintainable, also is not permissible. In view of the submissions of Mr. PJ Fukan, learned counsel for the applicant, I to Maribade 2505, registered to list this matter again on 6/5/2026.
My
No
lord,
further adjournment shall be granted.
My lord, can it be on 11, my lord? Another matter was fixed on
No, no,
11.
fix. We
My
go
lord,
by. Why
my lord,
are you making
my
it?
lord,
You
I'll
know
be-
everything.
my lord, I'll
It's
be
difficult
out
for
of-
me.
I'll
It's
be
difficult
out-
for me.
My lord, I'll be out of station, my lord. That is why, my lord, on 11th, my lord.
On 11/5/2025.
Most of them.
Yes, madam.
Lordship, in this case, we have taken steps, Lordship, upon respondent number.
When did you take steps?
We have taken steps. On 22/8, Lordship.
22/8/2025. Petitioner to take fresh steps for service of notice upon respondent number 5 at the correct address. She is in your school only.
Yes, Lordship.
Why don't you take Dasti?
Lordship,
Petitioner is also permitted to take by speed post query. A petitioner is also permitted to take to effect service upon the respondent number 5 by way of Dasti routed through the registry of this court. Steps within 3 working days from today. On effecting such service by way of Dasti mode, petitioner to file an affidavit in the matter. Registry to list this matter again after 4 weeks on a date to be fixed.
obliged, Lordship.
May I please, Your Lordship? My lord, as per Warima Court's order dated 27 feet.
No, respond number 2, we are not interested.
Yes, my lord, complete my lord.
Service upon the respond number 2 is complete. Also, now what?
So the matter may be listed for admission.
Oh, today is admission. You make your submissions.
No, my lord, in this matter, my one senior advocate will appear, my lord.
Yes.
Receive lots.
What is the instruction?
The affidavit lots are just for waiting lots.
Affidavit sent for waiting. How many days time? Where have you sent this affidavit for waiting? When did you send?
After lot.
Also, Mr. A. Bhattacharya, Learned Counsel for the Learned Government, A. Chakraborty, Learned Counsel for the respondents, Learned Government Advocate appearing for the respondent submits that the affidavit has been prepared and is in the process of being vetted and would be filed on or before 8/5/2026. Registry to list this matter again on 13/5/2026 for admissions.
My lord, interim order is there.
Interim order passed earlier to continue till the next date of this.
Right.
Wait, Your Lordship. I'm extremely sorry, my lord.
Yes.
Item number 44 and 45 were similar matter. 45 is disposed of, my lord.
Disposed of, close.
And 44 may also be kindly be disposed of with the same order, my lord.
44 to dispose the height. Yes.
My lord, 9 appears may be deleted.
I'll remove it. When Mr. Goswami comes and tells me, do I dare to not remove that? What are you saying?
Hello, the service is complete. My learned friend is appearing, my lord.
In this case, the authority is instructed me to appear. I have to file a color number also.
Mr. K. Gugoi, Learned CGC, Learned Counsel, under instructions have appeared for the respondent number, for the respondents. He submits all the respondents. He submits that he be granted further 2 weeks' time to file his affidavit in the matter. This one, we have passed the order. Only thing you got to do is to consider that and pass an order.
Just consider as per my.
Then where is that? Just give that compliance order. 6/1/25. Affidavit na lage. To place on record the compliance order. Registry to list this matter after 3 weeks on a date to be fixed by it.
Is already considered and rejected.
That just is that. Why, what is, that's all. So that Mr. Kolta can have a
He can receive
new set of things coming up.
only ground that deduction ground I just came to know from the lordship. The particular certificate issued for the lordship, not for the service perform, this for the lordship, education perform. That ground they have rejected.
Now you show me the certificate that is issued for service purpose.
Service purpose that format was given lordship.
Format signature is not there.
Certificate was, my lord, for the state government employment.
Okay,
And-
we'll see.
And it was central government
That's
post.
what he can challenge it, I did by way of affidavit.
Now, if we find that your compliance is not proper, we will not accept it.
Apply as per the procedure lordship.
As per procedure, we'll see.
But a procedure.
And the decision of this court.
Or lordship.
Obliged.
The office note reveals that the steps in the matter, that notice to the respondents were issued on 27/3/2026. Registry to await completion of service of notice upon the respondent numbers 1 and 2 for further 3 more weeks. Only on 27/3 it has. 2 more weeks, 2 more weeks.
Place before the minute, place with Lojama, my lord. They can verify from.
They'll automatically place. Where is your Dusty?
My lord, I have, there is a problem with the dusty is that, my lord, the petitioner is unable to take the dusty service, lordship. In the earlier case also, my lord, the writ petition, I have taken dusty and I have filed the affidavit also. Everybody had received their dusty notices, lordship, in a writ petition, lordship.
But be that as it may, now that IA we have issued a notice,
the petition
six has come here for 6. 6 has been served by usual.
But I have taken the usual process, lordship. I have taken the usual process, lordship.
Now, selection committee, we can forget that we can ask Mr. Tabildar to appear. But what about 6? 6 has to be served. 6 is served.
6 earlier also served, lordship. The writ petition was served.
Governing body?
Governing body also served, lordship, earlier in the writ petition, lordship.
No. Here, governing body not served.
Oh.
Huh? Principal 3, 4, why can't you take dusty?
I can take, lordship.
6 is already served.
6. Yeah, lordship. I'll take it.
5.
Within a week,
5 is again connected to 3 and 4.
Lordship.
Huh?
I'll take within a week, lordship.
Mr. DJ Kapil, Learned Counsel for the petitioner, submits that he would complete the process of service of notice upon respondents number 3, 4, and 5 by way of dusty mode within a period of 2 weeks from today and file an affidavit to that effect. So it is to be noted that respondent number 6 has already been served through usual process. Also, no. 6 has been served. 3, 5, 6. Oh, 4 you are appearing. Then we are doing it. Then we are doing it. Right. Out Mr. DJ Kapil, Learned Counsel for the petitioner. The office note reveals that the service upon respondent number 6 is complete. Also, however, with regard to respondent number 3 to 5, it is revealed that there is no report with regard to the usual process. Service of notice by usual process has been received, and the petitioner has also not filed any affidavit with regard to the affecting service upon the respondents number 3, 4, and 5 by way of dusty service. Mr. K. Kolita, Learned Counsel has entered appearance on behalf of respondent number 4. Accordingly, the Learned Counsel for the petitioner is directed to effect service of notice upon respondent number 3 and 5 through Mr. K. Kolita, Learned Counsel for respondent number 4.
I'll give him the extra copies, Lord.
The service of the respondents being complete, registry to list this matter for admissions on 2 weeks' time to file affidavit? Huh? 3 weeks, okay. On 25/2026. I'll give it, Mr. Kopek.
I'll give him.
So service complete, everything done. So you give it to him.
Obvious.
You are appearing for 4. Why what is 3 and 5? Same.
That's it, Lord.
Principal is something else. He's the secretary.
My initial submission is I am appearing for the respondent 4.
4. Yes. You appear for respondent number 4. We see you as the secretary. So 3 covered. Selection committee, you are a part. 5 covered.
Also, earlier also, in case of the writ petition also, he has taken the dusty, accepted the dusty on behalf of the others. I love it.
Now he'll have 3 briefs. You can give him a copy. He might even Xerox it in his own cost because he's having 3 now.
Lordship, this IA for corrections. Respondent number 11.
The present interlocutory application has been instituted. Heard, Mr.
DJ Boro.
DJ Boro, Learned Counsel for the petitioner. The present interlocutory application has been instituted for correction of a typographical error occasioning in the order dated 33/2026 passed by this court in WPC number 6792/2024. So, the applicant has submitted that the name of the respondent number 11 in line number 1, 2, 3. 7, 8, 10. Line number 10, 11, 12. In the said order has been recorded as Rupanjali Bora in place of Modhumita Bora. Also, this court has considered the said submission made by the learned counsel for the applicant and finds that the submission to be correct, and in fact a inadvertent typographical error has occasioned in recording the name of the respondent number 11. Also, the sentence wherein the name of the respondent number 11 was wrongly recorded is quoted, is extracted here in below. A to A, page 17. 17. Also, the said sentence would now be read as follows. Thereafter, the ward commissioners of the board held a meeting on 11/12/2024 and, therein, elected Modhumita Bora, that is the respondent number 11, herein as the new chairman of the board. The order dated 30/3/2026 be so read with the read in terms of the correction made with regard to the name of the respondent number 11 herein above. The present order be also treated to be a part of the order dated 33/2026 passed in WPC number 6792/2024. With the above observations and directions, the present interlocutory application stands disposed of. Yes.
Lordship. Petitioner is a cooperative society, Lordship, and
The order, where is the order which you want correction? Page 34.
Review as by anyone.
You file. Yes, which is the order?
Part man.
Here we had said 9%, but we had not mentioned from which date.
Yes.
So they filed a interlocutory application and we clarified there
Yes, Lordship.
that it will be from the date it was due for release, that is 28/2/2013.
Yes.
Now, what is your objection? Why you want a review of that?
I don't want a review. Lordship.
Yes, why do you want a review of that?
And the reimbursement bill come to my affidavit in original.
They have released that amount to you,
The admitted amount has been released.
but the interest has not.
Not yet.
Okay. Yes.
Thank you, my lord. Has highlighted guidelines. Paragraph 8, that based as per the terms and conditions.
Page.
Page 20.
50?
27.
27.
Filed in lead.
Affidavit in opposition?
Filed in lead petition.
It's not a part of this this review petition.
Here I.
Okay, we'll see. We'll see the page 27.
Eight matter. That with regard to the paragraph 5 of the terms and conditions sanctioned by the implementation of this. Unless the agency SIDC and price fix submitted.
No, this is only with regard to how you arrived at the amount of 2,03,000.
Yes.
Original demand was 2,50,000. You reduced it to 2,03,000. We have not said anything on that. You pay him 2,03,000 only. But for the delay occasioning, we have asked.
Regarding delay, madam,
Hmm.
madam, there are 10, madam.
Para 10. Okay, para 10.
That next to say for the sanction amount 2,03,000 for the investment was placed on 20. But would not be cleared within financial year. The petitioner sent a letter dated 1/3 of the same investment sanction. The approval of the reveal.
The writ petition is still pending.
Petition is
But the learned counsel for the parties. So as agreed to by the learned counsel for the parties, the connected writ petition being WPC number 5347/2020 would be taken up for final consideration and disposal. Also, the review petition would accordingly be considered along with the would be considered while considering the issue arising in WPC number 5347/2020. Yes, now you argue the writ petition.
writ petition, Lordship.
Anything left in the writ petition?
Yes, Lordship.
Oh.
Disputed amount, Lordship, has to be released.
That 2,03,000 has not been given. 4 lakh was your claim.
Yes, Lordship.
Now only 2,03,000 has
Yes,
been given. Okay. We are taking it up for final disposal then.
Yes, Lordship.
Yes, make your submissions.
Lordship, page number 12 of my writ petition. This is the order whereby my society was given the project for a duration of 6 months.
Page.
Page 12 of my writ petition, Lordship. In Exar 1. This is the order, Lordship. I was allowed to conduct the project. The project duration is 6 months. And Lordship, I have conducted the project. From the page number 12, Lordship, the first column, designer fee, including T&DA, is 2,50,000 rupees. So I conducted the project, Lordship, and after during when there is only 22 days remaining to complete the project, I was appointed. The present secretary was not the secretary at that time of the society. He was the engaged designer for the project, Lordship. When only 22 days was remaining to complete the project.
You are not before this. This is the society.
This is a society, but the issue is that only, Lordship. Because I was
the designer.
I was the designer engaged for the project, Lordship.
Engaged as secretary.
He was later on, when only 22 days was remaining, then he was appointed as secretary of the society, Lordship.
Yes.
As per terms and condition of this is admitted fact, Lordship. As per terms and condition of this.
Which is that terms and condition?
It is their affidavit in reply, Lordship. Affidavit in opposition of my writ petition.
It's there in page 12 also.
It's 34 of the guidelines. Terms and conditions.
Where is that guidelines?
Page 34 of my affidavit. A guideline that cannot be matched.
Which one? Relevant?
Class E, my lord, guidelines 2.
2E.
The organization.
The organization accept the design and technical institutions like NID, NIFT, IIT, so and so, handicraft corporation also to whom the design and technical development of project is sanctioned cannot engage their own member. I was not the member, I was the designer. Only for 22 days, I worked as secretary as well as designer only. Lordship, this condition was done and we exceeded that condition, and accordingly we have accepted the project and continued that. But certain exigencies occurred whereby the entire committee of the society has resigned. And because of that, I was chosen as secretary of the society. So for only for 22 days, there was no chance for the society to select a new designer. And for an ongoing project, Lordship, nobody may come to that project also to continue for just for 22 days, Lordship.
So by this time, the project, what was the stage of the completion of the project?
It was about to complete on 30th of September. It was supposed to complete, Lordship. On 8th of September, the entire society resigned, Lordship. I have annexed the documents also.
That clause.
We submit for you.
Managing committee members.
Entire committee resigned, Lordship.
Managing committee?
Yes, Lordship. So I became the secretary and also acted as designer. Lordship, if there is certain condition, there has to be some type of flexibility also. Otherwise, nobody can perform a project.
Okay.
And main objective of the project was for the development of the artisan, Lordship. And there is no dispute that I have not completed the project. The project was completed. And moreover, Lordship, if your Lordship come to the page number 12 again of my writ petition. The second line from first paragraph, third line, Lordship, 2010-11. Yeah, 2000, in collaboration with the Regional Design and Technical Development Center, Gauhati. This project was supposed to be completed in collaboration with this organization, Lordship. And in front of them, we have completed the project, Lordship. And after completion of the project, their respondent authority, Lordship, at page number 14, they knew that for just for 22 days, we have deviated for a certain bit from the conditions, Lordship. And because of that, page number 14, Lordship, their authorities, Lordship, directed to deduct designer fee for 1 month. If we designer fee for the entire duration of 2,50,000, Lordship. If we divide it by 6, it will come around 49,000 rupees, Lordship. So if they deduct for only 22 days deviation, if they deduct a sum of rupees 49,000, we do not have any objection, Lordship. But they are going to deduct the entire designer fee for 6 months, Lordship, 2,50,000.
Okay, then what happened?
And the reason they have given why designer fee cannot be fractionated is that designer fees cannot be fractionated. I don't understand why, Lordship. This is a sum of amount, Lordship, and they have genuinely completed the project. There is no such, there has not been such condition.
Now this 2,03,000 has been released to you.
2,03,000 has been released.
Yes.
Now what is left now?
Around 2 lakh.
Claiming, Lordship, 4,58,003.
Now how do you claim that? 4,58,000?
Because, Lordship, the project, it was of 10 lakh rupees, Lordship. Initially, 5 lakh rupees was released. 5 lakh rupees was supposed to be released after completion of the project. If now deduct that designer fee for 1 month, Lordship, so if we remaining 5 lakh, if we deduct the 1 month designer fee, Lordship, then it will come 4,58,333 rupees.
But come here, come to page 15.
50. 50, Lordship.
15.
Yes, Lordship.
What is this sanctioned amount? 10 lakhs. What is this HC share of admitted expenditure? 7 lakh.
This is, Lordship, they have that 2,50,000 they have deducted, and for prototype cost they have stated that.
Why is this deduction 7,03,000?
This is I can't show, Lordship. This, I think, Lordship, this 5 lakh rupees and the 2,50,000 and 43,000 rupees.
Now, do you admit that 5 lakhs is due to them?
My lord, you may come to my para 10 of
Hmm.
S29.
Hmm.
My lord. Then I am continuing. In the letter, it is sent to requesting revalidation of the
You are reading page para?
29, my lord, para 10.
That with regard to the statements when in para 7.
Yes.
Hmm.
The sanction amount of 2 lakh 3,000 was on 28 could not be cleared within financial year 2013. The petitioner said that 132. Approval of for sanction revalidation of sanction order should not be sought as utilization certificate.
Okay, come to para 11.
Pending.
Come to para 11.
Yes. They are, because the pre-receipt bill.
Come to para 11, read that.
Hello. As per the sanction order, the 5/1/11 project, China fee has not been in monthly basis subsequent to the 50,000 for violation of terms and conditions. Violation of condition of L and M lordship may come to my terms and conditions L and M final.
Page?
My just is
So according to you, if we hold the designer fee to be released to the petitioner, then let's hold that we hold that 2,50,000 is to go to him. So 2,50,000 plus 2,03,000 is what he will otherwise really receive.
my lord, lordship kindly for a moment, my lord, come to cross L, my lord.
Page?
Is 37. I am reading, my lord. The event of non-compliance of above instruction or non-completion of the project as per norms and parameters of the scheme, the organization shall have to refund the entire grant to the office of the development
Page,
commissioner.
in the event of non-compliance.
My lord, development commissioner handicap with penal interest which as per government of India instruction issued from time to time. The present rate of interest is 10%.
Okay, got it. So it is now the issue is 2,03,000 you have got.
Lordship.
2,50,000 you are claiming.
Lordship.
You are agreeable to only limit that, deduct the amount for 22 days.
Yes, Lordship. For 1 month, Lordship.
My lord, on the other hand, they have submitted pre-receipt bill also, my lord.
Pre-receipt bill for?
For 2 lakhs admitted amount, my lord.
That is the balance amount they have given, but this is disputed, so they had come before this court.
2,03,006.
And that also you delayed, that is why we have
No,
put
my-
interest.
My condition. And I'm. The reimbursement bill for the sanction amount of 2,03,006. Just on 20. But could not. Financial year 2013-14. Additional 5 letter dated 1/3/14, my lord. Annexure 5.
When was this amount finally released to you? I got it, Mr. Butsaji. When was this amount?
Lordship, it was released after the order, Lordship. Second order, they have immediately released. First order,
Undisputed amount.
undisputed amount. After the
Sir,
first order,
So we have passed we have said that that amount would be carry an interest.
yes, Lordship.
Yes.
So the interest for that interest you have come up on review.
Yes, Lordship.
So review dismissed.
Yes.
Review dismissed. Now what do you say about this 2,50,000?
Lordship, they are saying that we have not submitted utilization because of
That is
that.
there in the letter itself that no utilization
Yes,
certificate.
Lordship,
is
at
pending.
page number 16, final sanction order, Lordship.
No
Page number-
utilization certificate is pending.
It is there, Lordship.
My lord, it has not been.
Page-
So we have to now consider your review we are dismissing, and we will have to consider that whether that 2,50,000 would be given to the petitioner or not. And your own authority says that deduct for 1 month in the peculiar facts and circumstances
Yes,
of. Your only objection is, Mr. Vatsaji, that he is not entitled to do that 2,50,000 only because that he being the designer was also the member of the society. That the circumstances so required. That is why he became a member. Right?
Yes,
Now nothing is there.
Terms and conditions.
And Moreover, Lordship,
We'll consider that.
as per the terms and condition, Lordship, we have to prepare 2 sets of prototypes, Lordship, the model, Lordship. And that model we need to be submitted before the authorities of Lordship.
That will not go,
They have
we'll only by 22 days you have said.
Yes, Lordship.
Review petition. Heard Mr. P. Bhattacharjee, learned counsel for the petition. Applicant. Also heard Mr. A.D. Chaudhary, learned counsel for the respondent number.
One only.
Respondent, for the sole respondent. The present review petition has been instituted praying for a review of the order dated 27/6/2024 passed by this court in WPC number 5347/2020 as well as the order dated 9/29/2024 passed in I bracketed C number 2617/2024 bracketed arising from WPC number 5347/2020. Also, to the extent of the interest as ordered, as directed, the payment of interest as directed by this court for the area amount receivable by the sole respondent hearing. Also, this court, next, I've heard the learned counsel for the parties and also perused the materials available on record. This court wide order dated 27/6/2024 had directed, had by appreciating the fact that that an amount of rupees 2,03,660 was due to the petitioner society and the said amount was not disputed by the respondent, by the applicants herein, by the petitioners herein, and for which a pre-receipt was also submitted by the petitioner, had directed for release of the said amount of rupees 2,03,660 along with interest at the rate of 9% per annum from the date the said amount was so made. Also, a specific date having not been mentioned by this court in the order dated so and so 27/6/2024, the petition, the sole respondent herein had instituted an interlocutory application being I bracketed C oblique number 2617/2024, seeking a clarification in the matter. This court wide order dated 2/9/2024 had clarified that the amount of interest that would now be payable to the petitioner on the admitted amount of rupees 2,03,660 on account of the delayed payment of the same, would be at the rate of 9% with effect from 28/2/2013. It is submitted that the admitted amount of rupees 2,03,660 has however been released to the petitioner on after the passing of the order dated 2/9/2024 in I bracketed C number 2617/2024. Also, however, the interest amount was not paid and the present review petition has been instituted. This court has perused the contentions raised by the petitioners in the present review petition and finds that no material has been brought on record towards highlighting any error that has, any error in the orders review of which is being sought for. Also, the materials available on record reveals that there is no dispute with regard to the claim of the petition of the sole respondent that an amount of rupees 2,03,660 was due to it and a pre-receipt for the same was also submitted. The only reason assigned by the review petitioners is that the said amount was not permissible to be released to the petitioner society or to the respondent society only on the ground that the processing of the same had taken some time. Also, in view of the fact that no error has been highlighted to be existing in the orders review of which has been sought for, this court is of the considered view that by way of filing the present review petition, the petitioners have sought for a rehearing in the matter which is clearly impermissible. Also, accordingly, the present review petition stands dismissed. The orders dated 27/6/2024 in WPC number 5347/2020 and order dated 2/9/2024 in I bracketed C number 2617/2024 is held to is affirmed. Full stop. The review petition accordingly stands dismissed. Main petition likha. Heard the Learned Council for the parties at length. Registered to list this matter date 30th. 12/5 for delivery of orders.
Obliged, Lordship.
Yeah, said Mati. Really much good.
And in this case, as per last order dated 26/2/2026 and 19/3/2026, supposed to file the affidavit also.
Appointment orders, petitioner, effective undertaking.
It is already on record.
Again,
Undertaking and the appointment orders both are on record.
not in record, Lordship.
Yes,
And
has
new-
been
new-
produced.
New appointment, Lordship.
New appointment of 2021.
Lordship, what happened, Lordship? Can you have a look the order dated? 4/4/2025.
4/4/2025. 4/20.
The next page, Lordship, on considering the undertakings made by the petitioner 1 and 2, it is seen that there is nothing indicates therein that the petitioner number 1 and 2 have waived any right of their claim of ASLI, Lordship. So they have to file the affidavit, Lordship.
In fact, my lord, the
You have given an undertaking that you will be covered by the NPS scheme.
That undertaking regarding the ASLI.
Area salary is the stipulation in the,
it does.
that
And
you will
also-
not require
Also have a look the order that 3/2/2026, Lordship. There is a,
3/2/2026. Yes.
and there's an instruction produced by my learned friend, Lordship. On MS and for learned council for the so-and-so. Submits that petitioner illegal appointee so-and-so has been adjusted as discharged in Sibsagar district after obtaining an undertaking that no claim for any benefit whatsoever. in
Okay,
respect of-
fine. Now show me, okay, forget everything. Let us go to the root of the matter. Where is your initial appointment?
Lordship, initial appointment is page 23.
23. Now show me, how were you appointed? Where is the leading with regard to the advertisement, the selection, the appointment, everything? Where is the pleading?
Appointment address is page 23.
You don't have any inheritable right to get this job. Then show me.
That is true, Lordship. Let
True.
them file the affidavit.
So
and
that
I-
is true. One. Why? They are otherwise not filing an affidavit, and why should I pressurize them to not file an affidavit, to file an affidavit in a matter where it is not required? One. Two. Now tell me, this writ petition was pending before this court in 2017.
70.
You appeared before the screening committees.
We already appealed, Lordship.
You appeared. There is no dispute that you did not appear before the screening committee.
Appealed.
Why did you appear before the screening committee?
As per direction of the authority, Lordship, we appealed, Lordship.
Why did you appear? That means you are an illegal appointee or an irregular appointee. So
No,
that
Lord,
has now
the
been,
petitioners, after appointment, they went to the basic training, after they received the,
show me that your first initial appointment is by way of a selection process.
initial appointment, Lordship. Page 23 is the type copy, Lordship.
Show me that. If you are a selected candidate, why did you submit yourself? Or you took orders from this court that you will go to Subendu committee, SC, that committee. One. Two, why did you appear in the subsequent committee which was specifically for illegal and irregularly appointed teachers. Okay. You are appointed as teachers.
Yes, yes, sir.
That's the end of the matter.
But we have not, we have appointed, after appointment, we get the salary as a teacher.
Show me that your initial appointment is by way of a selection process.
That is not.
And you were
not in the
appointed
appointment
within
letter.
the
That is not in the
number of
appointment letter.
posts, within the number of posts advertised.
Advertisement, that is not with me, Lord, sir. And I have to take instruction.
No, that is the instruction you got to take on the first day, not today.
Advertisement, that is not with me right now, also.
Now show me.
After that, also they went to the basic training, also. After that, they received the.
Those things will not.
And
you are excess appointees directly. Otherwise, there is no reason why. And you approached this court earlier also. And therein the orders are there.
Yes, sir, that is their lordship.
Then how can we go beyond that?
On that order, lordship.
These are Sipsagar.
Sipsagar.
Oh, rotation. Rotation.
We are not rotation, lordship.
It's there in the writ petition, the earlier order.
Earlier order, lordship, page 39.
39. You come to page 40.
In view of the
Second paragraph.
In view of the above, it is hereby directed the cases of the present witness shall be placed before the committee. As per the execution of this order, we approach before the appear before the committee, lordship.
Committee then found you to be illegal appointee, but in the list one, that is why you are regularized as. And an affidavit has also been filed by the government here.
The application of the categories can taken by the government.
We got it.
Then there was no advertisement. There is no denial in the reply.
As such, this excess teachers along with the got their salary up to February 2012.
Regarding, we have not undertaken anywhere that we will not claim our area salary, lordship.
You show me that your initial appointment was done in the procedure known to law. Take the order. I have disposed of a number of writ petitions in this line now. This court's finding is that you are in that rotation system, and people who are in the rotation system are persons who have been appointed in excess.
A similarly appointed person.
You have got a job now.
The similarly appointed person who working in the urban area, they have received a salary from.
File a PIL to that effect.
From that.
Or file a PIL with a prayer for co-warranto.
In paragraph 21, lordship.
You file a PIL or a writ petition with a prayer for co-warranto. We will then look into it. Anything more? You have my that orders passed in this matter. You have my orders that I have passed. I'll get it. Anything more? A Birospati Twidiado. But the counsel for the parties at some length. Hearing remains inconclusive. Registry to list this matter. Kukurbara India. Bondosini. Birospati. 30.
The subsequent appointment orders are also.
That is during the pendency of the writ petition. Will be not that hyper technical.
And in the reply, my lord, they have not denied that, my lord.
So, lordship, we have admitted that we have been appointed newly as a teacher. But our claim is in the writ petition is regarding the ASL.
You got a new, I have scanned your writ petition,
so that,
but I don't find any statement there.
On 3 to 23, the coordinates directed them to.
What took me against you is 2 points. One, you have not denied your appearance before the committee which was considered.
Yes, admittedly.
Secondly, my Lord Justice Ansari's order, wherein there is a categorical finding recorded that you are all illegal teachers, irregular teachers, and you have been paid by that rotation system. That was innovative method that was put into place, and you were referred to a committee. That committee is this committee. Now that committee's recommendation is not under challenge anyway.
That is true, that is not challenge lordship, because this
This is pending. You should have come up with, when you got that order, you should have, that order is of 21. Now we are in 26. You should have challenged those orders.
So lordship, sir, liberty may be granted, lordship.
You withdraw it, I'll give you liberty.
Because
But
in this case, my.
But the thing would be the same. This is going in the admission stage, that will go in the motion stage itself. Guaranteed. If it comes before me. We'll pass the orders, don't worry. We'll dismiss it, then you take up in the appeal and do whatever you want. That's it. No more hearing. No more hearing. I'll pass the order on.
Lordship, lordship.
You got it?
Para
Yes.
13,
Huh?
para 13 of the writ petition, my lord.
Para 13.
Yes. He is admittedly junior to me at page 38, your lordship, the gradation list, serial number 22. Sitaram Dole.
What is the name of that man?
Which one, my lord? Sitaram Dole.
No, no, Dijendra.
Dijendra.
Where is Dijendra?
Dijendra.
Your case is against Dijendra.
Yes,
Not against Dole. Dole is gone in cast.
that's true, your lordship.
What is your case with Dole? How do you project it?
Lordship, but I have made this statement, and your lordship, one more factor. Motor vehicle inspector as well as assistant enforcement inspector, equal footing. As per lordship rule.
Oh, let us not open it too wide now.
No.
You went as enforcement inspector.
Yes,
Or checker inspector.
yes,
And Dijendra Nath Das also went as enforcement inspector.
yes.
Dole, forget it. He has that caste benefit.
Roster will follow.
Now, you were not considered Dole, Dijendra Nath, but
Yes.
subsequently you were also given, considering that Dijendra Nath was.
Yes.
Now, Dijendra Nath Das's promotion is cancelled.
Now they have come up with the finding.
Neither does it.
Yes,
It will go back to that date.
yes.
Now, why should your retrospective promotion be not
Lordship,
interfered with?
that affidavit, the stand taken by them has been, lordship, and his promotion, your lordship, kindly see, the annexure annexed by, by way of affidavit is of 2000, it's the order of 2025.
Neither does it. This matter is pending before this court.
Yes.
So
I'll
this court
Yes,
can undo,
yes.
saying that public money, let it remain in the exchequer. It should not
That's
go to
right,
West
it
Point.
would go. So lordship, today, since there are orders of this honorable court, lordship, yes.
Yes. What is your case?
My case, lordship, the gradation list annexed in the 7, page 7. The petitioner name reflected serial number 6, which is new. 7, Dizendranath Das, whose promotion has been cancelled by the department, lordship. That the immediate Asif Ahmed. The lordship may kindly have a look the page 12, the tag mark I have. Page 12, the meeting.
No. Where is that merit seniority position?
That page 7, my lord. Of course. Of my instruction.
So 6 is Dipjyoti Niyog.
Instruction from them.
Oh, madam.
Yes.
Just. Dipjyoti Niyog is 6. Dijendra Nath Das is 7.
7.
I will not go beyond this.
Yes.
6 and 7. Where is the minutes?
Page 12.
Hmm. Hmm.
12.
Hmm.
Lordship,
Hmm.
we got page
Hmm.
meeting recommending for and then on 3 to
Hmm. So here, Dipjyoti Niyog was recommended,
5
Ah.
and his immediate junior is Asif Ahmed.
but the promotion was made in respect of this man, Dijendra Nath Das.
Here promoted 2019. So Deputy Niyog was given promotion with effect from the promotion.
Okay. So Dipjyoti Niyog was promoted in 2020, basing on the recommendations. But his immediate junior was promoted in 2019. Why?
Cases are pending.
Pending. So normally, do you know what I'm trying to project?
Yes, I didn't get.
You have cancelled his promotion will still not take away the retrospective effect because she was there. He would have been promoted from 2019, not 2020. Only reference point was Dijendranath Das. But Dijendranath Das's subsequent cancellation will have no effect on the promotion made to in respect of the petitioner.
Yes.
Because he otherwise would have been eligible for promotion in 2019 only. Why should we go for any other thing? We will close that. Now you get what I mean.
I'm not getting the instruction, that's why.
No,
Yes.
it's there in your writ petition.
It's page 38 of your petition. The
Oh. Yes, 3839, yes.
Madam, if you were to be considered properly,
Yes,
you would have been promoted in 2019.
yes, my lord.
For some reason, you were not promoted, and then they said that, okay, a junior, because you were not promoted, Dijendranath Das.
Yes,
If Dijendranath Das goes, you come in.
yes.
Now let me dispose of.
That is possible.
Yeah.
At the Learned Council, for the parties at some length. Hearing, I'm just putting it, hearing remain inconclusive, I'll pass the others.
Man. Obliged.
We'll take it up. Next week, but next week, no, second week. Okay. No hearing, we are passing it. I just wanted clarification.
My lord. Lordship is giving it
14, we'll dispose it of.
Right, okay.
Now, hearing on it.
In this case, my lord, counter affidavits have not filed, my lord.
Forget your counter affidavit. Tell me your case.
My lord,
Yes, who is appearing for the respondent, number 7? You are appearing. Okay.
Inspection is available because of my first convenience, my lord, it was not filed. Lordship, my last opportunity, my lord. Because my affidavit is very important, my lord.
Yes, what is your case?
Case, my lord, in the year 2005, I was engaged on casual basis in a grade 4 in a Gao Panchayat, my lord. By
Mr.
the
Doctor, Madam, take your seats.
page 14, my lord, kindly
Hmm.
see my engagement letter. Page 14, my lord. 10/5/2005, I was engaged as a peon as a casual basic peon, my lord, on honorarium of rupees 300. Since then, I have been working, my lord. Various duty certificate is there, time to time by the authorities, GP authorities. Now, recently, my lord, the case is in 2021. In the year, my lord, kindly see page 26.
Now, whether the person Abdul Hasib has been regularized?
No, not regularized.
Not regularized.
Not.
So, if he is not regularized till date, what is the beauty in asking for your regularization?
By my subsequently,
Now,
my lord,
after Upen does, you are not entitled to
my
regularization.
humble submission, my lord. The case is that the cause of action arises page 26. Subsequently, one newcomer, the respondent number 7, has emerged, my lord, in a document, my lord.
And here the date of joining is 3/3/1997.
Yes, my lord. These are all absolutely, my lord, manufactured, what I am claiming, my lord. These are all manufactured documents. We never
Yes,
seen him.
Mr. Doctor, what do you have to say with regard to whether respondent number 7 has been regularized? Yes, madam, have you been regularized? No.
As per my instruction, petitioner is never appointed by our department, my lord.
These
Or
are-
any Gao Panchayat secretary. He was, as per instruction, he was working, my lord, service holder, doing service in Southeast Borderpur Cooperative Society Limited. It is nearby our Gao Panchayat office.
My lord, these are the documents available, my lord. Now, what happened? The
You are
respondent,
working till date?
I am working till date.
Yes, madam, you are not regularized. When did you join? What is the document to show that you have joined on that day?
Private respondent is working 2020
Where do I get it?
in my instruction only. That is why I want to file affidavit.
Forget affidavit. You show me, give me that instruction. Affidavit will take this matter for another 5 years down the lane.
That person was in Nagaland, my lord.
Copy of service. Attendance register.
Okay. But Learned Counsel for the petition. Also heard Mr. S. Datta, Learned Standing Counsel, Panchayat and Rural Development Department. And Madam, your name? M. Bora, Learned Counsel, appearing for the respondent number this one. 7. Mr. Datta has placed on record the parawise comments received by him in the matter dated 3/1/2022. Also, perusal of the said parawise comments reveals that the petitioner is not a person employed by an official of by an officer of the Panchayat department, and it is also projected that the petitioner is working in a cooperative society, namely Southeast Bodorpur Cooperative Society Limited, Mahakal. Also, in view of the said position, they said the view of the above, Mr. Datta is directed to file an affidavit on behalf of the respondents represented by him on or before 8/5/2026. No further adjournment shall be granted in the matter. The respondent number 7 also shall bring on record an affidavit. We shall also file an affidavit in the matter on or before 8/5/2026. Tabishat, tumi lastot likhiba, no further adjournment. Upor likhisa no, tolot likhiba, no further adjournment. Registry to list this matter again on 15/5/2026 for admission hearing. Ready, ba?
Published.
I know.
Oh, dismissed. Yes.
Instruction legal. You will kindly see page 87, my affidavit. Query was that on the first advertisement, person working, make that Bhavananda Bora
He died in,
Why it is not reflected here?
yes, like, he died on 30/6/2021. Much prior to the advertisement.
So what is this sanctity of this roster register that you have prepared? Huh?
Was due return,
But you have not even made a note to that effect. This is prepared after, I think, the
after the
Mm.
first advertisement.
Mm.
Only 3% are working.
This is after 24 you have prepared this. So you have not even reflected that. Why?
Presently, 3% are working in this, for promotional. And, Minmoy Nath and Ajit Bhuya. Ajit Bhuya post is a new mailer. And the Rostapon 8 SC that has been filled up, set limit. Now total persons are working in this unit.
This roster register is not correct.
Possible see that, page 86.
Click on some services from you. This is the 8th vacancy. Now the fresh advertisement,
8.
8th vacancy. No, not the first one. The first one will be how much, which number vacancy?
The second one is 7.
No, first one would be, advertisement is of 22.
22.
So it will be 1, 2, 3, 4, 5,
7.
6, 7.
7.
So first advertisement ought to have been, no, yes, 7.
7. What are
7. 7. But you notified it as 1.
1? That was the corrected by the annexer, page 86. My opinion.
So how did you, that carry forward is there of SC vacancy?
Another thing I'll like to bring to your lordship's notice that I am a person belonging to the SC category.
The SC?
Yes, yes. I applied for this UR category, UR PWD.
Some relaxation?
Yeah, there was a relaxation, yes. No, relaxation because when the first advertisement was issued in the year 22, I was of the age of 43. So relaxation was not necessary because that was already there.
So you participated as not as a SC candidate, but as a general committee?
Yes. So what had happened, as because this in the roster point, the lordship may come to the roster point at page 29, which we have annexed in the writ petition.
Yes.
Now, if your lordship comes to roster point 1, Habananda Bora, as because he expired on 30/6/2021, before the date of retirement, this advertisement at page 21.
Advertisement to that extent is correct.
Yes. Thereafter, this communication dated 2024, which is at page 65, 28 May 2024.
Communication was correct.
With reference to your letter on the subject quoted above, I am directed to state that as per your furnished proposal regarding
The problem is, Mr. Dutta, what you say is correct, but they follow this, they are not following the replacement formula. They are following this L-shaped thing. 4, you go ahead. So every vacancy that is there, so that is being done. That is being upheld by coordinate benches also. So to that extent, they may be right, but otherwise, once the 4 posts have been filled up, as per R.K. Sabharwal, 1995, 2 SSC, supply 2 or 2 SSC, the roster is gone. It cannot be further operated. What you got to do is now replacement. So if we apply that, your submission, yes, correct, first vacancy, replacement would be your PW.
Your PWD.
PWD comes in from that PWD list, wherein the first vacancy has to be PWD. But the thing is that on a totality of the matter, you're 10%. Well tried, but I'm sorry. Next time. Heard the learned counsel for the parties at length. Hearing remains inconclusive. Raised it to list this matter, did the DDA hold. Then, khali thaka dina dia. Nine. Kundina 19. Fine. I'll pass the orders on.
Obliged.
Obliged.
I have sent my affidavit for.
We will not accept that because you have been taking time, Mr. Bodloy, since the date the notices were issued on 9/9/24 and your affidavits have not come on record.
If otherwise, end of the department is that they themselves have admitted in the writ petition bit of a sum. The closure of the.
Fine, whatever it is, they have gone, but.
Because they are the
period-
permanent resident of
Oh,
UP
Mr.
and
Counsel,
yes,
please. For the period they were working, they are entitled. They are
And they
entitled
have
to
not
the
submitted-
VRS benefits also.
Yes, sir. And in fact, they have not submitted the required documents before the liquidator, your lordship.
No, for that, if you had so much of knowledge about the subject, why was it not placed before this court? I'm finding this in every case now. The matter is getting, we will dismiss the writ petition, no problem. But where is your material?
Grant me 2 days time, your lordship.
I'm sorry, that's not very sad experience. I'm not getting it. Because this order was passed on 30/3/2026. And you said that you had some personal difficulty on that day. Before that, on 17/9, again, you are on behalf of you, again on 18/8, nobody appeared. 23/4, 2 weeks. And notices were issued on 9/9/24. And see, the matter is pending. Only order sheets we are recording that you are taking time. And one day they have taken time. Mr. G. Bodloy, learned counsel for the respondent number
Appear for respondent 2 and 5, your lordship.
respondent number 2 and 5 submits that an affidavit on behalf of the respondents represented by him would be filed without fail on 5/5/2026. Registered to list this matter again on 8/5/2026. In the event the affidavit is not filed on 5/5/2025, such affidavit would be permissible to be filed by the respondent number 2 and 5 on payment of rupees 25,000 each before the registry of this court. Also, registered to list this matter again on 8/5/2026.
Obliged.
So the cabinet decision for lordship, it was done in the year 2024.
No, what about the earlier part? They are entitled from 20, before that.
Lordship, there is a notification.
Hmm.
It will be counted from the initial date, that is 2022.
That's it. The senior scale and selection grade will also have to be considered accordingly. They were regular appointees. There is no dispute that you're a 3F appointee,
No.
cabinet regularization, nothing. I only want to know why 24 you said okay, cabinet decision. Why not 21 when he was eligible? Or you tell me why he became eligible only in 24. I'll ask Mr. Bhattakur.
And on 29 January.
No.
And on
You consider it whenever you want, but the benefit is conferred by UGC, we'll have to go to that date.
It order to go, second order. I mean, I put it like this. What person? Dated 2025. No. Belage koisa. 88 no সেইখন আমাৰ petition পাছত সেইখন
You cannot have this decision because by this you are now creating two classes. Mr. Bhattakur, go through it.
Lordship.
He has brought it. But why this cabinet decision was mandated? Because you have there is a office memorandum or notification on issued by the higher education department, laying down the manner in which this has to be done. Now, why this? What is this PDUAMS? In none of the cases, affidavit.
This is Pandit Dindayal Upadhyay.
Oh, that one. That cannot be equated with a college under the UGC. Mr. B. Upaman, Learned Standing Council, Higher Education Department has placed on record an instruction received by him from the Director of Higher Education, Office of the Director of Higher Education, Assam, wherein it has been stipulated that, wherein it has been highlighted that the caste promotion in the CAS Dangroma in respect of the petitioner was so done basing on a cabinet decision dated 22/1/2024. He has also placed on record a notice issued. A notice dated 8/8/2025 issued by the Director of Higher Education Assam in the same direction. Copy of the said documents be furnished to Mr. S. Bhattakur, Learned Senior Counsel appearing for the petitioners. So, Mr. Bhattakur shall make his submission after perusing the said documents on the next date of listing. Registry to list this matter again on when?
In the second week of May.
On, let us have it on 14. 14/5/2026.
In fact, your lordship, that cabinet decision have not been translated into an order, your lordship. Only based on a cabinet decision, how can without having an order they can?
You make those points.
Lordship.
And you get the background.
Yes.
Deeply obliged.
Mr. Upamanyu shall also apprise this court as to whether the petition, as to the date on which the petitioners had satisfied the eligibility criteria for being promoted under the CAS, under the CAS, Career Advancement Scheme. Career Advancement Scheme, huh? Yes. There was none in the morning when the matter was called up. Did not, why, then why are you here today? He could have, she is waiting from the morning here. Ms. S. Borua, learned government advocate, submits that she be granted further 10 weeks, 1 year, 2 year, what? 4 weeks time to file an affidavit to bring on record the stand of the respondents represented by her by way of filing an affidavit. Prayer accepted. Registry, prayer is not disputed by Ms. B. Chaudhary, learned senior counsel appearing for the petitioners. Full stop. Registry to list this matter again after 4 weeks on a date to be fixed by it. Full stop. The interim orders passed. Interim order passed earlier to continue till the next date of listing.
Much obliged.
Site at a same order. তোমার হবো এইটা item number 30 no sorry 34 to 34 35 36 37
Much obliged.
বেলেগ কে মারিব yes
We do not raise the file of.
I have.
Mr. Kolita is very powerful.
But
Lordship, page 6, that is addressed to the petitioner, but care of Principal Bozali College. They have to show records that we have, the petitioner has received us. Because I have in award in paragraph 10, Lordship.
Heard Mr. K. Kolita, learned counsel for the petitioner at some length. Mr. J. Patwari, learned counsel appearing for the respondents number 3, 4, and 5. 3. Respondent number 3 has placed on record a show cause notice issued to the petitioner on issued to the petition by the Director of Higher Education Assam, dated
24/04/2017.
dated 24/4/2017, instituting a departmental proceeding against him. Also, Mr. Kolita submits that the said show cause notice, however, was never served upon the petitioner. Mr. A.R. Tabilda, learned counsel for the learned standing counsel, Higher Education Department, shall receive instructions in the matter as to whether the said show cause notice dated 24/4/2017 has been served upon the petitioner, and if so served, the date on which such service was so effected. A perusal of the show cause notice dated 24/4/2017 reveals that the same was sent to the petitioner to the principal, Bozali College, Patsala. So, the principal, Bozali College, Patsala, shall also apprise this court through Mr. J. Patwari, learned counsel appearing for the Bozali College is not there now.
No.
The university, who is the university then?
Bhattadevi University.
Mr. J. Patwari shall also apprise this court as to whether the said as to whether the show cause notice dated 24/4/2017 was served upon the petitioner by the authorities of the erstwhile Bozali College and or by the present Bhattadev University, Bozali. Get it? And you just issue a show cause and you forget.
Now. File should not be placed.
You mean to say that the petitioner is responsible for that? Where is your FIR to that effect? Huh? Don't come up and tell me that you have lost the file. I'll have it hauled here. If you have lost it, show me what you have done to recover that.
Lordship, fix a date, Lordship. Yes. Very powerful, Lordship.
Very, very powerful.
That's why Lordship may fix a date. Date.
Registry to list this matter again on 7/5/2025 for further hearing. It's already on record.
Can it be on 11?
You get your instructions. There is much time, nearly more than 10 days.
আমার pro bono case করি আছে।
And you find out whether Mr. Kolita, I mean, the petitioner is responsible.
Pro bono case, Lordship. That's why.
No, you can't take money from such big people, such powerful people. But gives a very bad impression, Mr. Both of you. Yes. No, no time will be allowed. When? When did you seek that calculation? If it is immediately after the order, then fine. Okay. Ms. N. Fukan, learned counsel appearing for the respondents on instruction has submitted that the calculation of the interest, a calculation of the amount receivable by the petitioner as interest for the delayed payment of his arrears salaries is being processed, and the same would be completed within 10 working days from today. She submits that the matter be taken up after 10 days, on which date she shall place on record the orders passed towards authorizing the petitioner is the interest component with regard to the delayed payment of his arrears salaries in terms of the directions passed by this court. Prayer accepted. Registry to list this matter again on 12/5/2026. Also, the respondent herein shall place before this court the order issued towards authorizing the petitioner his arrears, the interest with regard the authorizing to the petitioner amount working out as interest for the delayed payment of his arrear salaries. Order will have to come on record. A copy of the instructions furnished by Ms. N. Fukan, learned counsel, is kept on record and marked as X for the purpose of identification.
No placement.
We have filed affidavit in reply. We have filed an affidavit in reply.
Hearing the matter,
My
urge about
my
the
Petition is against a private entity.
you urge Mr. Dr. VAB.
My senior
submission
lacks
regard-
on lacks in.
You said you wanted in the second half, I put it in the second half.
I am not asking. Time.
Who asked? Okay, now you argue.
My senior is on legs. In court number 17.
You have kept a senior counsel waiting here.
Grant some time.
LIC only has a nominal holding there. It's not even 50%. And the others are not government entities. It's a pure private dispute. Earlier, you came before this court, you went before the tribunal, 2A. You exercise the provisions of 2A of the Industrial Disputes Act. The tribunal gave passed some order, they came up before this court. This court found that you are not, that proceeding is not proper. Because 2A could not have been invoked. This court directed you to go before the civil. That order has attained finality. Forget the Kerala High Court judgment. That's not binding on me. But the reasonings which are there on a coordinate bench, that is binding. When can we have it?
After tomorrow,
Any urgency on your part?
the transport has been split. The day when they moved it, I clarified the entirety of the thing, legal position. Then the file your affidavit, I filed.
So file your detailed affidavit. Who is your senior?
Adhar.
Ad hoc.
Tomorrow it is better.
Thing is that I have fixed up a lot of matters. She is looking at me now.
The reason I did not say day after tomorrow.
বুধবারে একে অবস্থা না? 8. 8th. She is saying next week.
Very small matter.
But, your name?
A Wahid.
Eh?
A Wahid.
A. Wahid, Learned Counsel for the petitioner. Also heard Mr. S. Dr. Learned Senior Counsel appearing for the respondents. Mr. Wahid submits that that the matter be adjourned today, as his senior is on legs in another court. Also, Mr. Dr. Learned Senior, Mr. He is here. We'll hear. Yes, Mr. Dhor.
My lord. My lord, today only we have filed an affidavit in reply.
Oh, we have filed an
explaining-
affidavit in reply.
My lord,
We'll consider the
The
matter.
only question whether the LIC HFL comes within the purview of Article 12. That we have replied and we are relying upon a division bench judgment of Kerala High Court.
We are not going with that because that is not binding. It only has a persuasive value insofar as I am concerned.
My lord.
And the reasonings are okay, fine for that extent. But there is a case involving the parties here. You and the LIC,
My lord.
wherein this court, a proceeding from the industrial tribunal or the labor court, whatever it is,
Yes.
was put to challenge. And this court has said that you don't have a jurisdiction.
No.
Then it says that that proceeding 2A.
That proceeding is bad.
2A was because it was 2A that
2A.
was bad. And it said that go before a civil court.
Competent civil jurisdiction.
So same thing, why should we entertain? That order has attained finality.
My lord, that question my senior will answer, assist your lordship.
Oh, he said that you are the senior. Now you say that there is another senior.
Mr. K.N. Chaudhary is leading me.
Mr. K.N. Chaudhary is here in this case. Okay, fine.
So we have filed our written affidavit in reply,
We have
which will
got it.
explain that affidavit in reply that your queries from your lordship that has been
Dealt with. Okay, show me.
well,
That is the only area. Where is the affidavit in reply? I didn't hear.
that has been filed today.
And asked him to call for it. You have not called for it.
It was filed around.
Lord, your lordship can
Yes.
relying on this Kerala High Court division. This judgment is against the office court.
Involving LIC housing.
It's Federal Bank Limited.
Federal Bank, and then
Exactly.
there is a series of judgments.
Into my lord, private entity.
Federal Bank is again a scheduled bank.
Purely a private entity.
So where is your technical please with regard to that?
Well, that LIC, they are saying that the LIC HFL is not, does not have any.
It's not a statutory body.
Not
one. It's a simple, pure and simple company registered under the company's register. LIC has got no direct control over that.
Yes.
It's only a board. To the extent of the board members, it will have a control. The central government through LIC does not enforce any control over LICH, housing finance.
Yes.
Till LIC, there may be some control by the state government, by the central government. But through that, you will have to presume a control on the housing finance company. But there is no, otherwise there is no direct control.
But the LIC, that is why I have filed this.
Now show me,
showing.
LIC being a corporation,
Yes.
it has gone up and done a business venture in collaboration with somebody else, which is not statutorily backed. Whether that would bring it within the provisions of Article 12. There are decisions pertaining to this insurance companies.
That I have not checked, my lord.
And this court is very clear on the same issue. For redressal of your grievances,
Yes.
the court has said go before the civil court, and this order has attained finality.
Yes, we have filed this writ petition because this comes within the purview of Article 12. That is why this has been filed.
No, but when that plea was available to you, before this court also, earlier court also.
Yes.
So that plea was not taken there.
No, my lord, that writ petition was filed by the LIC.
I got it, but when the court says that for this, you have now been directed to a particular forum. Now, I being a coordinate bench, I can't go against this.
My lord, that is true, but in my understanding, paragraph 16.
And your own submission, that is on the submission of the learned counsel, senior counsel of the petitioner, that he will go before the civil court.
Yes.
Now, why this? Why should we take a different view from that? Because that is continuation. This issue is the same issue that is now before this court. The basic issue involved therein. You were here, you went there as credit manager. Then during that proceeding, you were brought back.
Yes, by the LIC.
But you say on a lower stage, but that is on merit. That's the issue which was there before the tribunal, before this court.
Issue was before the learned single judge was whether Section 2A application.
We got it when the learned single judge had said, if the learned single judge had stopped there, and this is without jurisdiction. But the learned single judge, basing on the submissions advanced, proceeded to determine the forum. Para 4 and 5.
Para 4 and 5. 3 and 4.
So in page 65.
65. 3 and 4. Paragraph Roman
shall not preclude. So if it was a state, you should not have made this submission. And this holding the field, how can a coordinate bench go beyond that?
Let it be on day after tomorrow. My senior will address on this. Because this aspect was.
Mr. Ed Hoc, learned counsel for the petition, also heard Mr. S. Dr. learned senior counsel hearing for the respondents, assisted by senior S. Dr. learned senior counsel, assisted by Mr. S. Dr. learned counsel for the respondents. Also, Mr. Dhar has submitted that an affidavit in reply, a rejoinder affidavit has been filed today to the affidavit filed by the respondents. Also, Mr. Doctor has expressed urgency in the matter and accordingly praised that the matter be taken up on a short, at a short date. Also, considering the submissions of the learned counsel for the parties, registry to list this matter again on 11 তারিখে কেন কাজ 8 তারিখ 8 তারিখে পাই না we'll have it on 8th on 8/5/2026. Parties are at liberty to make a prayer for an out of turn hearing of the matter on the next date of listing. but it will list the matter along with the affidavit, rejoinder affidavit filed by the petitioner. Yeah. Very good. And what is that federal bank? There is one more. You also check up.
I'll check up.
There is, so doctor, you also make
And
an
this
entry.
is the last, Kerala High Court Division Bench judgment is the last judgment I find.
But the other high courts have gone against you.
There is contradictory judgments also.
Because on the, mainly on the point that it was a body having a state government statutory body creating a board, that would be a dangerous precedent then.
All the private bodies will.
All will come.
The articles, after considering the articles of association, the Kerala High Court given the judgment. I will show on the next.
Articles of
Say barely because 40% share.
42.5%, it says that it is just below 50%.
It's not a government company.
We'll see.